Good morning, all. This application hearing is in the matter of CFI 062-2021 before His Excellency Deputy Chief Justice Ali Madhani. The claimants are represented by KBH Limited. Lead counsel is Mr. James Knott. The defendant is represented by Al Tamimi and Company. Lead counsel is Mr. Sharif Shivji KC. Thank you, Your Excellency.
Good morning.
Good morning, all.
Good morning.
Sharif, Mr. Knott.
Good morning.
But you just made my weekend miserable.
Oh, well, I'm so sorry.
I'm sorry.
We're hoping to make the next couple of days a bit more pleasurable. In fact, on our side, we're hopeful that we might be able to deal with things a bit more swiftly than we previously anticipated. Can I raise just a couple of points about agenda and housekeeping? And there's an issue between my learned friend about sequencing. And if I introduce that, then my learned friend can also have an opportunity to give his observations, if I may.
Indulge my ears, please.
Yes. The first point is that I appear in this matter for UBS AG, which is a successor entity of Credit Suisse AG. I appear with Mr. Olive Cooper and Miss Rita Jabala of Al Tamimi and Company. UBS AG are not currently a party to these proceedings, but they need to be substituted. I don't understand there's any dispute between the parties on that, but we've put in a substitution order, and that is in the bundle at page 2486. Now, just on the bundle, there have been various versions of the bundle.
Would you please repeat the reference? 2486?
That's right, page 2486.
I don't seem to have
I know, that's fine.
with that.
That's fine. If you're working from the e-registry bundles,
yeah,
that will be bundle H, tab 11.
Please bear with me.
Of course, no problem.
Seems like I'm have more than one bundle. Maybe I'm opening the wrong bundle. So we're referring to the latest bundle that was refreshed on the 2nd of September.
If it assists, there are two bundles. There is an application bundle, which is the longer bundle, and then there is separately to that a bundle.
The supplementary bundle and the application hearing bundle. So there is actually three bundles before me. So now you want me to refer to
the main application bundle,
the submitted
please.
Bundle on the called the application hearing on the 15th.
That's right, exactly. And the document I want to go to is in index H for hotel, and then tab 11, please.
Yes, I'm in there. Tamimi letter.
It's a Tamimi letter, and then if you go to the next page, if you go to page 2489,
yes,
there is a draft order.
Yeah.
Now, ordinarily, it would be for the claimants to apply to substitute a defendant because obviously they want to get an order against a party that exists. They haven't actually made an application, but that's no issue as far as we're concerned. We're quite happy to agree to an order, and we have put forward an order at 2489 and 2490 that simply substitutes UBS AG in place of Credit Suisse. And as we understand it, that's the standard order that would be made on a substitution. So Credit Suisse no longer exists. UBS is the successor entity, and we're quite IAP for UBS, and we're quite content for UBS to be substituted in.
So would this be issued on a consent basis or just court order?
Well, maybe in a moment you can hear from my learned friend on that. If I may, can I just make a couple of other points, and then I'm conscious he'll want to say something as well. So just in terms of the landscape for today and possibly tomorrow, if we get there, there are two main categories of application before you. There is the claimant's application for a document production order, and those are essentially standalone issues of documents the claimants want from us. And then separate from that, there are 3 other applications. There is my application for a document production order against the claimants. There is my application for further information, and there is
I've just lost Mr. Shivji, I think. I don't know if everyone else has.
Yeah, I have lost him too.
I'm so sorry, I got disconnected for a moment there. Can you hear me now? Don't know why.
Yes, Mr. Shivji, would you please repeat what you've been saying about?
Yes, I'm so sorry. I don't know why there was an issue at my end, but I'm back on. So there are essentially 2 categories of application. There's my learning friends application for a document production order. Those are standalone issues that just arise on his side, things that he wants to raise with you. And then separate from that, there are 3 applications that are connected. And they are my application for a document production order, my application for further information, and the claimant's application to strike out parts of my pleading on their classification. Now, the further information application and the strikeout application are quite small and limited, but they overlap very heavily with my document production order. And in my view, logically, they ought to be heard together. Now, in terms of the sequencing, it doesn't matter too much. My learned friend, I think, is very keen to go forward with his document production order first. If that's how he wants to proceed, then I'm not going to object to that. But after he's dealt with that, my suggestion would be that I come on and then deal with the remaining applications together. That seems like the logical order to deal with things. Now, we've put together an agenda, and I'll just show you the agenda as well. That's in the supplemental bundle at tab B, tab 2, page 376.
Yeah, I see that. Call it the draft agenda.
Yes, so that's that hasn't been agreed, but that's my agenda.
For the hearing, you mean?
Yeah, for the hearing, for the next 2 days. Now, that document's hopefully helpful because it gives you a list of the things that need to be decided over the next couple of days. But as I've said, I think the only issue really between me and my learned friend is that he wants to go first on his application for a document production order. And I'm content with that so long as I can go next on my application for a document production order. And if I may, what we've done in our agenda is set out the categories where document production is an issue. So you have a shopping list of categories in dispute, which I hope will help. And this is one final point before I hand over to my learned friend, which is that on his document production order, you've probably seen from his skeleton that he spends a lot of time dealing with the contact notes. It's the single largest item in his skeleton argument. Now, actually, we have already given a copy of the contact notes, and I have a proposal that I hope will satisfy him on his contact notes. So maybe I should set out that proposal quite early in the hearing, so he's heard what I've had to say, because actually, I think that our proposal should cut down the submissions on the contact notes. I don't actually think that there is a substantial dispute for the court to resolve, because we're quite happy to give them. And I was just going to explain what we're proposing to give. But again, I'm in your hands as to when I do that, but I just don't think we need to spend a lot of time developing the submissions on the contact notes when, in fact, on the things that matter, I don't think there is much in dispute.
Do you mean that you're still seeking instructions in regard of the hyperlink related to the contact notes to be delivered to the claimant?
Can I explain if I may, I'll just explain our proposal on the contact notes. It's going to take me 3 or 4 minutes to do that. But if I may, I'll just explain to the context and what we are offering to do. And that, I'm hoping that might actually shorten the hearing. So if you will allow me to do it, please.
Please go ahead.
Thank you. So on the contact notes, we have gone to considerable efforts to provide the claimants with what they want. And before the proceedings even commenced, we had provided the claimants with a full set of the contact notes, and that was done on a voluntary basis. And we've also provided extensive other agreements and other documentation. Now, you will have noticed from the document production dispute more generally that originally there were 41 categories of documents where the claimant sought document production. And we've been very accommodating on that as well. And before you today, there are only 7 remaining categories that are in issue. So they're happy with our answers on the other 34 categories. Now, one of the categories that remains in issue is the contact notes. And it's common ground that these contact notes sit on a bespoke system in Credit Suisse, in Credit Suisse's internal network. And that internal network is in Switzerland. Now, the claimants don't run a system like our internal system. So the data needs to be extracted from that system in a format that they can read. If we gave them purely the raw data straight from the system, if they gave the raw data, they wouldn't have a mechanism to view it because they don't run that system. It's a bespoke system that we have in Switzerland. Now, my learned friend spends a lot of time in his skeleton argument saying that he wants the original native form of these documents, that his wording, the original native form, and that's wrong, we say, for 3 reasons. Firstly, this idea of a native document is an English disclosure concept, not a DIFC Part 28 concept. So you'll find no reference to a native document in Part 28. Whereas in the English disclosure rules, there is a regime for native documents. So my first point is the regime is different and native documents don't have a home under the RDC. The second point is that, and I've sort of already foreshadowed this, that the native data in this case is the underlying computer code that sits within our database. And as I've said, that computer code is going to be of no use to my learned friend. So the native data is not going to help him. The native data has to be extracted in a form which is readable. The third point is that my learned friend says that we have to produce the original. Now, actually, that's not the Part 28 regime. The Part 28 regime says under Part 28.20 sub 4 that a party may produce copies. That is the standard document production order, is that you provide a copy of the data. And that it's obvious for electronic data that you have to be providing a copy. You can't provide the original. I can't go and get the computer from Switzerland and transport it to the UAE. So we say for 3 reasons, my learned friend is wrong when he's asking for the original native data. That's just not a regime that's known, we say, to the DIFC. It's an English concept. Now, we are very happy to provide them with a full set of the contact notes extracted directly from Credit Suisse's internal system. We have to provide that to them in a readable format, otherwise they won't be able to view it. And the format we'll provide it is in Excel format. And we will include within that extraction metadata, specifically the date of creation of the contact notes and the date of modification. So, and we will also provide the attachments to the contact notes as well. And we will provide alongside all of that a statement from an IT professional at UBS, who is otherwise not involved in this case, who can verify that the data is being taken directly from the system. Now, all of that offering goes above and beyond what is required under Part 28, but we're happy to do it. Now, Your Excellency asked about the links and whether we could get the links to work. And we can't get the links to work And the reason for that is that the linking is not something inherent in the document. So the documents, if you extract the documents in a readable form, they don't contain a link. And that's because the link is not native to the document. It's not a fundamental part of the document. It's a part of our systems. And the systems actually that have the attachments are a different system to the system that have the contact notes. So that is not something that we can recreate for them. If we could simply recreate it, we would do it. But also under RDC 28, they're not entitled to that. I mean, that's something we can't do, and they can't point to a part of the order and say, you, the defendant, have to give functionality that you have on your internal systems. That isn't part of...
Understood, Mr. Chavji. Thank you very much. I appreciate...
So that's my proposal. Anyway, I've said enough.
And I'm sure your proposal is before Mr. Nutt now for consideration, and he might be seeking direction as well, directly. And then I hope Mr. Singh, who's behind the screen, would agree to that. Two, okay, this is to say, I mean, before I turn to Mr. Nutt for, also I remember you said you didn't mind who start first. I mean, what is in my mind, I'm content to allow the claimants to go first. Yeah, I would ask him to also keep the application related to the contact note to be the second application and the first application. So he might start with his strikeout application first. And then by time we hear from him in regard of the strikeout application, then we might have an answer from his far end about your proposal related to the contact note. Then we'll allow you to defend the claimant application and produce your own submission related to your application. And then we might give him back, we'll go back to Mr. Nutt to rebarrel your applications in a certain way. Well, as I said, well, it seems lengthy applications, but it doesn't seem very complicated for us. And I thought our party has invested more than proportionate time and effort to put this 4 application together. 35 and over 50 pages of skeleton argument is quite a lengthy for this level of case management. However, we've gone with that. We've allowed this. I am not sure if parties have seek the court permission to submit such lengthy submission related to the application. But I might understand when you're coming from different 4 application, so you might convince the court there is a merger of submissions in regard of 2 different application where together might be called as a heavy application, but not a single one. Every single one of them, I would not call it a heavy application. I think it's straightforward. I mean, just to recap from that, I think I have dealt with this case many times before. And then my understanding is this case related to a bank and client investment, fund investment mechanism, where the claimant bringing this case is for mainly 2 grounds for breach of regulatory framework and then mis-selling of high-risk products, wherein the bank's defense is that these 2 gentlemen are a professional financial players in the market. They have conducted a lot of them by themselves, and the bank is entitled to trade with them at that high level, high risk, potential investments. So this is to be said, I understand there is 2 applications from the claimant. One of them for a production of document, mainly the contact note, and the other one for strikeout, a defense, but by the claimant, again, to the central point that the claimant are a professional financial person. And this is, I think, is a key question to the case for the future development. Then I understand they are a defense from the bank against both applications. There might be some change of circumstances this morning being said by Mr. Shavji related to the offer that's being put in regard of a contact note. and I hope the claimant will be content with that. That's my wish. Then we would look at the application, look at the RFI, the information required by the claimant, and the set of documents that the DBO application put by the bank against the claimant, which containing, I think, big cluster of documents. So that is to be maybe discussed in length. But so straightforward, I'm content for the claimant to kick off with, I didn't need to hear a lot about the background. I have read the case in this case many times. I have gone through most of the document. I have updated. I mean, to be honest with you, I'm even reading this case since 6 in the morning. So I spent last 3 hours, 4 hours reading, educating myself about it as well. So, so I'm not expecting from so not a lot of background and things. So you might get directly to the point of this. As I said, with the preference that you did with the strikeout application before your other application, so we might have a direction that the matter is dealt with already. Mr. Knott, you may please the court.
I'm very grateful for that indication, and I will address the strikeout application first in that instance. Just before I do, just in relation to timings, our understanding from the link that we'd been sent in our conversation with the registry was that the hearing was listed between 9 and 2 today. Is that correct?
Oh yeah, it's a good question, because I hear from Ms. Shafji that this case is going for 2 days hearing, which is in fact not. This is what isn't my diary, which is I'm alerted by the DIFC registry, is this case is set up for 5 hours, but not for 2 days. Yes.
Okay,
yeah, and I'll reconfirm to you, the maximum we can go today is 2:30. That is the maximum, because I have to start with another hearing by 3 o'clock.
I'm very grateful for that indication.
And there is no tomorrow. And there is no
finally,
tomorrow.
Before I start, do you have any preference for particular timings for breaks or any break during this hearing, so that the parties can be cognizant of that?
I said this would depend on what your instruction you're going to get related to the defendant offer this morning.
Very good. I've sought
to the other
instructions on
production. Yeah, if that's positive, so we can, I think then we can hear from you, and then we can hear the instructions that you received. If the instruction negative, you will go ahead with your application, and then we will pause for short break, not more than half an hour, and then we will turn to Mr. Shafji to address his defense against your application and addressing his application, and then I'll come back to you to defend yourself after Mr. Shafji's step down.
Very good. So to turn directly to the strikeout application,
please.
Your Honour will, I hope, be familiar with the law. It's set out at paragraphs 58 to 61 of my skeleton, which one can find in the supplemental bundle at A2, tab A2, page 44. But the short point is that under RDC 4.16(1), the court may strike out all or part of the statement of case if it discloses no reasonable grounds for defending the claim, and essentially the test is whether or not the case or the pleading has no realistic chance of success. So that is the target that I'm aiming to meet. If we start with the relevant pleadings in respect of the challenge, and I'll do so by way of example, because each of the paragraphs that we seek to strike out is in materially the same form. So we can start, please, in the main bundle, the applications bundle, at A, tab 2, page 52.
Page 52?
Yes, that's correct. And it's paragraph 65 of the amended particulars of claim. So this is my pleading. And it's about halfway down the page. You'll see paragraph 65. And it starts, the defendant fails to determine whether each of the claimants was a professional client in accordance with COB Rule 2.3.2. Then, if I may invite your attention to over the page, 65.5. There's the case that to the extent that the defendant did undertake any analysis, neither that analysis nor the information supplied by the claimant provided reasonable grounds for the defendant to conclude that the claimants appeared to have sufficient experience and understanding of relevant financial markets, products or transactions or any associated risks. And then there are set out the various reasons. So that is the case to which the amended pleading that I seek to strike out is responding. And we can see that at A tab 6, page 237. And it's paragraph 84.8 towards the bottom of the page. And the amendments, I hope you can see they're in red at the bottom of the page. And you can see that this is...
You said page 237?
237, it should be. It's paragraph 84.8.
What bundle are we talking about? This, the main bundle or the supplementary bundle?
Yes, the main bundle. So it should be tab A6. And page 237. Or there's also internal page numbers in the document itself, and it says page 46 of 90 at the bottom.
Yeah, I can see the red font here. Yes. Yeah.
Yes, I'm very grateful. So there are the new pleas there. We can see first 84.8. It's with regards to 65.5. So that is the allegation that the defendant didn't have reasonable grounds. And there are two new pleas. There's 84.8.1a, which for present purposes I don't take issue with. And then 84.8.1b, which is the paragraphs I seek to strike out. And one can see there the question as a matter of law and fact of whether the authorised firm had reasonable grounds to conclude that a person had sufficient experience and understanding to be classified as a professional client is informed by how other financial institutions had classified that person at the time and the grounds on which they did so. Now, it's important in my submission to note the hypothesis on which this plea is made. And it's based on a hypothesis that, firstly, the defendant did conduct analysis in relation to client classification. Now, we don't accept that, but it's our alternative case that if they did conduct analysis, they didn't have reasonable grounds. And the hypothesis that the bank did have reasonable grounds to classify my clients as professional clients. And it's premised on a proposition that the classifications by other banks are relevant even if the bank itself didn't know about them at the time. And we say that is wrong as a matter of law. And we can do that by reference to the COB rules. And we'll look at those now. One can find those in the supplemental bundle, starting at, please, A14, page 268.
The rule book, did you say?
Yes, that's correct. Yeah. So that's the rule book, just to identify the document. And if we go over the page, right, we can see, starting at 2.1.1, we can see that it applies in little 1 to an authorised firm carrying on or intending to carry on any financial service with or for a person. And then the guidance under 2.2 This chapter describes the manner in which an authorized firm classifies and treats its clients. And then the guidance at little 2 under 2.2.
Yes.
An authorized firm may choose to provide financial services to both retail clients and professional clients. In those circumstances, the authorized firm must determine the appropriate classification of its clients. Note there, the authorized firm is the one having to do the determination. As a consequence of the analysis under Rule 2.3.2, which we'll come to, it may be that a client is a retail client, a professional client, or a professional client in relation to certain services and products, and a retail client in relation to other services and products. So two things to note from that. Firstly, it's the authorized firm doing the assessment, and secondly, a client can be both a professional client for some purposes and a retail client for other purposes.
So you're saying it's the bank duty to do their due diligence and then identify the client according to 2.2 of this rule book as either like retail client, professional client, or professional client in relation to certain services.
Yes, and then we come on to essentially the machinery for that, which we find at 2.3, which one can find on page 270, just one page onwards. So at 2.3.1, under the heading Types of Client,
yes,
again, before carrying out a financial service, an authorized firm must determine whether a person is a professional client, and they must do so in accordance with Rule 2.3.2. And that brings us on essentially to the key provision, 2.3.2 itself. An authorized firm may classify a person as a professional client only if, then we can ignore little a, and little b, subject to 2, appears on reasonable grounds to the authorized firm to have sufficient experience and understanding of relevant financial markets, products, or transactions, and any associated risks, following the analysis specified in Rule 2.5.1. And in my submission, the key words for present purposes there are appears to the authorized firm and following the analysis specified in 2.5.1. Now, I'll come in a moment to that analysis under 2.5.1.
So appears on a reasonable ground.
Yes.
I see.
And I'll come in a moment to the analysis that's required under 2.5.1, but pausing here, what we can note is that there is a sequence of events that this rule contemplates. First, an authorized firm must determine if a person is a professional client. How must it determine it? It must do so in accordance with Rule 2.3.2. What does 2.3.2 require? First, the firm must undertake the analysis specified by 2.5.1, and next, following that analysis, it must appear, based on reasonable grounds, to the authorized firm that the client has the necessary experience and understanding. So the focus here is on, firstly, the analysis the authorized firm is required to undertake, and following that analysis, what appears to the authorized firm. And we can note in passing that on the next page, under little 2, there are a whole list of circumstances in which an authorized firm can consider a person a professional client without having to undertake the required analysis. And in my submission, it's relevant that none of those circumstances includes where other banks have classified the client as a professional client. Now, the relevant analysis that is required to be carried out, we can find at 2.5.1, which is on page 273.
Yes.
And we can see there, for the purposes of Rule 2.3.21b, which is what we've just looked at, the analysis undertaken by an authorised firm must include, where applicable, consideration of the following matters. And then we see a list of the sorts of things that must be taken into account. And we can see under the guidance, under that rule at the bottom of the page, it's again referring to consideration by the authorised firm and reasonable assurance being held by the authorised firm. And then finally, just in relation to these parts of the rules, if we go over the page to 274, we can see Rule 2.6, headed Record Keeping. An authorised firm must keep records of the process undertaken under the rules in this chapter, including any documents which evidence the client's classification. And those documents must be kept for at least 6 years from the date on which the business relationship with the client has ended. So again, the focus is on what the authorised firm knows at the time, with a requirement to keep records of the evidence that it relies upon. And again, there is no contemporaneous record produced by this defendant that it relied upon classifications by other banks as of the claimants as professional clients. And so drawing all of that together, in my submission, the COB rules as regards classification are quite clear. The focus is all on what the authorised firm knew at the time. It's what analysis the authorised firm conducted at the time based on the information that it had. Nowhere are these rules aimed at analysis or conclusions reached by other firms. And in my submission, that accords with common sense and it accords with public policy. In my submission, the COB's rules present a unified code telling firms what they must do, how they must do it, and what they are required to take into account when doing so. And had the rules been intended to permit an authorised firm to rely on analysis and conclusions by other firms, they would have said so. They don't. And there are a number of indications in my submission that that's the case. First, as we saw under the COB rules, they specifically provide for circumstances in which an authorised firm can classify a professional client without having to undertake the required analysis. As we saw, those don't include classifications by other firms. And secondly, where the rules do intend that an authorised firm should be entitled to rely on classifications by another firm, they say so expressly. And we can see an example of that, again, in the same supplemental bundle at tab A15, page 302. Apologies, that's a bad reference. It's page 300. And Rule 2.4.4.
Yes.
Reliance on a classification made elsewhere. And we needn't read it in particular, but it doesn't. That situation doesn't apply to the facts of this case, and it certainly doesn't apply to classifications by other professional firms unrelated to the defendant bank. And so in my submission, having now looked at the COB rules in relation to client classification, those demonstrate that the proposition advanced in the pleading that I seek to strike out, and we have perhaps go back to that so we can have it before us. It's at main bundle A6237. (84.8.1b). And we do say that the proposition advanced there, that the question whether an authorised firm had reasonable grounds to classify as a professional client is informed by how other financial institutions classified that person and the grounds on which they did so. In my submission, that is not supported by the COB rules and is bad in law. Now, there are a number of reasons.
So this goes to the heart of defendant application for production of document as well, because that's what they're trying to do, yeah?
Yes, that's why, as my learned friend and I accept, there is a significant, although not complete, a significant degree of overlap between the strikeout application and my learned friend's RFI application and his DPO application, because by those applications he seeks, amongst other things, information about my client's relationships with other banks. In part because he wants to be able to say, by reference to this plea, well, we didn't do our job, so we didn't do, you know, let's assume we didn't do our job. These other banks did, and we can rely on that.
So in short, you're saying any classification done by any third party won't help them anyway, so.
Yes.
So that, yeah, that render their application is completely unnecessary. So the only facts and merit the court should look at is the bank own classification at the time.
That is what.
Yeah.
Yes, and if I may just develop that submission, just briefly. The first point, as we've seen, is there's nothing in the COB rules themselves to support the proposition that is set out in 84.1b and the similar pleas that essentially make the same point. Secondly, what is clear from the COB rules we looked at is what's required by the authorised firm is a decision. You've got your information, you conduct your analysis, and you reach a decision. Now, in my submission, it's common sense that the question whether a decision taken on the basis of certain information that the decision maker was required to have regard to, the question whether that is reasonable falls to be assessed by reference to the material that the decision maker had. And you might, I suppose, draw an analogy with the sorts of cases that sometimes crop up in English law, where you have a question about whether somebody had a reasonable grounds for arresting somebody, for example, and that there you would test that by reference to the material that they had when they formed the decision. And that stands to reason, because where the question is whether a decision maker had reasonable grounds, you focus on the grounds available to the decision maker. Otherwise, it changes the question. And it changes the question from whether the authorised firm had reasonable grounds based on its analysis, and becomes a new question or a new test, which is whether, objectively speaking, irrespective of what was known to the authorised firm and irrespective of the analysis carried out, the client was objectively a professional client. But that's not what the COB rules say, and it's not what they require. And equally, as we saw in the guidance, a client can be a professional client for some purposes and a non-professional client for others. And so in my submission, it makes sense that an authorised firm is required to carry out its analysis contemporaneously and in the specific context of the financial services it is proposing to provide. And if the reasonableness could be tested by reference to classifications by other firms, you would need to know, the court would need to know in each and every case, the nature of the financial services that were being provided by that other firm, the context in which it was providing it, the regulatory rules to which that firm was subject, and indeed whether that other firm was itself relying on classifications by other firms. And all of that, we say, would entail an investigation and analysis after the event, which is simply not contemplated by the rules. And in my submission, the point is reinforced by the requirement under the rules, which we've seen, for the authorised firm to keep records, both of the analysis that it carried out and the documents it has relied on. And indeed, we can see from the defendant's records themselves, what little there are, tends to reinforce the lack of relevance of other banks' classifications to the defendant's analysis. So, for example, if one looks at the questionnaire for advisory clients, which is in the main bundle, tab D3, page 707, we can see that there's no analysis in here of classifications by other banks. And if one turns to page 709 at the bottom, section 2, we can see there's a division between analysis performed by the relationship manager, and then there are a whole series of questions and answers reporting to be from the relationship manager, and then under B, separately, other banking relationships on 711, but no reference to analysis carried out or whether they were professional clients. It doesn't come into it. And similarly, the what's been referred to by the parties as the knowledge and experience, or the K&E form, page 713, again, makes no reference to classifications by other banks. And so, standing back, and to summarize, we say the rules require information to be gathered, they require analysis to be carried out, and they require a decision following that analysis. And there's simply no room on the basis of the COB rules obligations to introduce an ex post facto after the event analysis by reference to decisions or analysis carried out by someone else who may or may not be subject to the same rules. And so for those reasons, we say that the plea that I've identified cannot stand. Now, my learned friend in his skeleton seeks to meet the application essentially by focusing on the word reasonable in 2.3.2. And what the defendant says is, well, aha, reasonableness imports an objective standard, and that's informed by market practice, and so ipso facto classifications by other banks are relevant. Now, I'll, of course, let my learned friend develop his submissions on that in due course and respond to them at the appropriate time. But just very briefly, so the court knows what our position in relation to that to be. As regards reasonableness, as we've seen, the focus is on whether the client appeared to the authorised firm on reasonable grounds to have the relevant experience and understanding. But equally, and in any event, the rules themselves provide the criteria by which the reasonableness is to be tested. We saw them, it was under 2.5.1. So the rules as a unified code provide the test, the criteria by which the reasonableness can be tested. And when combined with the requirement to keep records, it creates a very straightforward basis for a test of reasonableness. One looks at the information that they had and the documents relied upon, one looks at the criteria under 2.5.1, and one can decide whether or not the decision was reasonable, the grounds were reasonable. And notably, Rule 2.5.1, which sets out the criteria, does not include market practice or generally accepted market practice amongst other banks. That's not a criteria of the test. And secondly, even if, which I don't accept for the reasons I've just given, but even if market practice were somehow relevant to the question of classification under 2.3.2, that is a matter, or would be a matter, for expert evidence, not documents of fact. It would be for a suitably qualified expert to give expert evidence on what is generally accepted market practice at other banks. Now, there is provision in the case management order made in this case by this court for expert evidence. Now, no application has yet been made, and the time limit for making such an application for such expert evidence has not yet passed. But that, if it were to be pursued, would be the appropriate way to go about seeking to prove market practice. So, as I say,
well, do you really think there is a room to allow an expertise? I mean, in order to convince the court about something is off a legal regulatory matter?
well, I don't.
But
I
you
say
will
that
go
this
to
is
the custom.
purely,
Yeah, you will move
purely
from the
under the
law
COBS
to the
rules.
custom, I guess, from that basis.
But what my learned friend says in his skeleton, and the way he puts it is using these exact words, market practice. He says, well, reasonableness imports an objective view, and you look at market practice. And that's at paragraph 77 of his skeleton argument. And my submission is, now I don't accept that for the reasons I've given. I say the COB rules are a complete code. They give you your reasonableness criteria. But if I'm wrong about that, and if my learned friend is right that there is some relevance of market practice, you don't test market practice by looking at what banks did in relation to a particular client. You look at general market practice, and the way you prove market practice, certainly as a matter of English law, and there's no reason to think that it would be different under DIFC law, is a suitably qualified expert. And indeed, one sees that in the cases that my learned friend has cited. As I say, I'll deal with those in reply, but after my learned friend has made his submissions and developed them as he wishes to. But just to flag that those are, in a nutshell, our responses to those. And so we do say that for all of those reasons, and I'm conscious of the relatively limited time we have available, that is why we say these pleas have no prospect of success, and indeed are bound to fail and should be struck out.
So consequently, if your application is granted,
Yes.
would that mean an automatic dismissal of the defendant's application for production of document and information related to the same main issue, the classification?
I would very much like to be able to say yes, but no, it doesn't. My learned friend has, in fairness to him, other grounds on which he advances those aspects of his application. It would, in my submission, go a very long way to providing the court for a reason for dismissing it, because plainly the primary, or we would say the primary basis for that application is aimed at gathering information to deal with the classification case. There are similar submissions to be made in relation to the suitability tests for products, which arise in the context of my learned friend's RFI application and his DPO application. They're not strictly necessary to the strikeout, because the plea that I'm dealing with doesn't go to suitability of products, it only goes to client classification. But I'll deal with the suitability elements
In your defense
in those events. But if the court is with us on the strikeout, then it certainly, in my submission, would be a very, very powerful factor standing against my learned friends, or the bulk of my learned friends' applications.
Much obliged. Would you please take some moment and try to seek instructions in regard of...
Yes, it may be that I've had some whilst I've been talking. So if the court will indulge me one moment for me to check.
Please take your time.
Yeah, I think just looking. I think it may be that I will need to have a quick discussion with my solicitors and clients just to get instructions, because I think there are some elements of the proposal that we may want to query. So it may be that we can use the break that the court had in mind, or bring that break forward as an opportunity for me to speak to my clients, such that if we can iron that out, that would obviously deal with a significant part of my application. I'm not in the position at the moment to say yes, because I simply haven't got instructions on it. I think my solicitors would like an opportunity just to discuss it with me.
Would 10 minutes would be sufficient for the discussion?
Certainly in the first instance, I can endeavour to try and get an answer in that time.
Then we shall break for 10 minutes and come back. We'll see you
I'm
in
very
10 minutes.
grateful.
Thank you. Yes, Mr. Knott.
I'm very grateful for that time. I've taken instructions. Obviously, it would have been helpful to have had the proposal before the hearing rather than right at the beginning. But obviously, we still don't actually know what the underlying files that are being referred to are in terms of their format and so on and so forth. But on a pragmatic basis, we are prepared to agree to the proposal that has been tabled by the defendant, provided that we can raise queries with the data once it's provided in due course, and reserving our right to reopen the application if it becomes apparent that there is something missing or some other discrepancy that we feel needs to be determined. In my submission, that's only right on the basis that there is going to be, we're told, a verification from an IT expert. We may wish to run that past somebody ourselves to make sure that it is confirming what it says it confirms, and confirming this type of file system, and that we've got all of the metadata that we should have. So in my submission, we are prepared to accept it on the basis that we reserve our right and have a liberty to apply to come back if, and it may not be necessary, but if there's some issue with the data that we're provided, because we don't know what it is, we don't know what it will look like, we don't know what the IT person is going to say.
Actually, it's not a big deal. I will understand your concern about the methodology of the production and about it, the IT complication related to it. I mean, let's put this application aside, and it's to be discussed at lunchtime between counsels. And let's proceed now with the defendant's application.
If I just very quickly, I'm sorry, there is a balance of document production requests, document production orders that I seek under my application, which don't relate to the contact notes. I'm very happy to deal with those later.
I agree with that. Yeah. You may
Shall I deal with those now?
Yes,
I'll proceed. Okay. Just right. So as you say, we'll come back to the contact notes after I've had a chance to discuss that with my learned friend. So the first of the balance of my requests are requests 22 to 23, and these relate to internal policies, guidelines, or procedural manuals relating to assessment of suitability and those sorts of things. And I can deal with both of them together because they both seek essentially similar policies and guidelines. And I can do it by reference to the objection that the defendant raises, which is that it is said the request is not sufficiently relevant and material. And in particular, the defendant says that determining the adequacy of the defendant's policies and whether the defendant followed them won't assist the court as to whether the defendant conducted an adequate suitability assessment for relevant trades. And we say that's not right, and that it takes an unduly narrow approach to the significance of these documents. And the COB rules, and I'll come back to the COB rules in relation to suitability in the context of my learned friends applications in more detail, but in short, they require the defendant to have a reasonable basis for considering any particular product that they recommend to be suitable. And we say that whether or not they had a reasonable basis may well be informed by, firstly, whether they had internal policies and guidelines as to suitability and the like, and secondly, whether they complied with them. And the same points can be made in relation to the COB rules relating to communications with clients. And we say that we can see how important such policies and procedures are from the DFSA's own guidance. And we can see that by way of example in the main bundle at tab C6, page 572.
If you allow me to ask you, would this argument still, I mean, be a live argument, like if the court, for example, are not with you, whether now or later at the substantial hearing, that your client is a professional client? Would this still be the question as a stake?
Yes, because if whether or not my client was a professional client or not, when advising in relation to trades, a suitability analysis still had to be carried out. And so that would arise in any event, irrespective of the classification case, the mis-selling case still arises. And so whether or not a product was suitable is essentially a discrete question.
So this would go to the how reasonableness the discretion applied by the bank and choosing what product to trade in, isn't it?
Yes, so they're two separate things. So when a bank opens the relationship, it may choose to classify as a professional or non-professional. So that's classification, and that can inform the question of suitability, because obviously the more knowledge and experience a client has, the more likely it may be that any particular product may be suitable for them. But the rules are very clear, and the guidance to which I'm about to take you is also clear, that each product that is recommended must be subject to its own suitability assessment. And indeed, the DFSA's own guidance makes clear that what a firm shouldn't do is simply rely on the material that it used to classify the client as a professional and non-professional client.
And 22 and 23 class of document is related to the bank's policy in this regard, isn't it?
Yes.
It's not published? It's not, aren't they supposed to be published?
Not to my knowledge. I think I'll be corrected by my learned friend if I'm wrong, but I think generally the policies of that sort are internal to the bank. So they would be used by the bank's personnel when assessing whether a product is suitable, assuming they exist, which we don't know. Yes. But if I may just take you very briefly to Please. 572 at C6 572.
What bundle we're talking about?
The main bundle. Sorry.
Main bundle.
Main bundle C6 572. And I should take you to the document at the beginning first, on page 566, so you can see what the document is. So it's called the Thematic Review on Suitability, published in 2021. There is background and methodology set out in the pages that follow. And in summary, the DFSA conducted a review of authorised firms' approach to assessing and recording suitability up to 2020. And if one turns to 572, one can see at the top the second observation made by the DFSA. Authorised firms' control documents, for example, policies and procedures, frequently restate the DFSA's suitability rules and guidance, but fail to address how they will be implemented and ensure compliance with them. And then in the second main paragraph below that, the DFSA rulebook modules set minimum standards. The DFSA expects authorised firms to develop and implement codes of conduct, systems and controls and governance oversight tailored to the specific needs of its business and to provide practical direction and guidance to staff to enable them to comply with applicable DFSI rules and internal policies. And then the next paragraph, COB Rule 3.4.2.1 prohibits firms from recommending to a client financial product or service or executing a discretionary transaction unless they have a reasonable basis for considering the recommendation to be suitable. Subparagraph A requires authorised firms to undertake an appropriate assessment. And then the next paragraph, we observe no instance in which an authorised firm explained in its compliance manual or elsewhere what constitutes a reasonable basis. And then finally, the DFSA expects, in the last paragraph, the DFSA expects authorised firms' policies, procedures and governance to provide sufficiently clear direction to achieve appropriate suitability outcomes in compliance with the rules. So in my submission, these documents are plainly relevant. They would record how the bank set itself to comply with the rules and would be relevant in the court's assessment of whether the bank had met the minimum standard which is applied by the COB rules. So those are my submissions in relation to those documents. We then come on to request number 37. Perhaps easiest to do this by reference to the request itself, which is at B main bundle B/4/452. So it's 37 at the bottom of the page. Written records of telephone calls, for example, itemised telephone bills made or received on the defendant's or Clarendon DIFC's behalf from the claimants, to or from the claimants for the periods 2012 to 2020, and then including and then listed below are 4 telephone numbers, which are telephone numbers belonging to particular relationship managers that the clients had at the bank, the claimants had at the bank over those relevant periods of time. And the objection pursued for this request is that the records are not in the defendant's possession, custody or control. And there are 2 bases given for that. The first is that the defendant doesn't maintain these records itself. And the second is that they're not kept by its phone operator for more than 6 months. Now, in my submission, if it were to transpire following a search that the defendant does not in fact and cannot obtain these records, well then so be it. But we do say that the explanation that has been given to date is not a sufficient answer for a number of reasons. The first is that the defendant has not explained in its evidence how it can be the case that as a highly regulated global bank, it doesn't firstly receive and secondly keep itemised telephone records for a period of more than 6 months. Now, we've had an assertion from the defendant that that's the case, but no explanation as to why. Now, we know that the defendant is able...
Any obligation in the bank to keep the record longer than that?
Well, we saw from the COB Rule 2.6 that there is an obligation to keep records insofar as they relate to any of the matters it's required to investigate for the purposes of suitability, client classification, for a period of 6 years from the end of the relationship. Now, that end of the relationship would have been in around 2021. I don't think I can point to anything in the rules which requires specifically itemized call records to be kept for any particular length of time beyond any particular time. But it is, in my submission, surprising, given the regulatory obligations on the bank, that it doesn't. And allied to that is the fact that we do know that the defendant is able to list some telephone calls in an itemized way, because it was provided to the it has provided to the claimants a version of the document which we can find at E41067, the main bundle, E4, page 1067, which is a very long list of telephone calls with dates, times, durations, parties, etc. And what we don't have is an explanation as to how they can produce this document, but at the same time don't have records beyond that and can't produce what we've asked for. And it's not in evidence, but I'd say on the basis of instructions that my client's understanding is that phone companies in the jurisdiction will generally send email or electronic bills. And if they were sent, it's to be expected that at least some will be available. But in the absence of a sufficient explanation as to why they're not, then in my submission, it would be appropriate to make an order. And as I say, if after a reasonable search it turns out that there aren't any, then so be it. But in all of those circumstances, we do say that an order is appropriate. And somewhat related to that is the next request, which is request 38, which one can see at page 453 of the main bundle, so B4453. And this is seeking recordings of calls between the defendant and the claimants, which have not previously been disclosed. Now, we know from the list that I just showed you, that's a very long list, it runs to something like 2,700 calls, which were, we understand, recorded between the claimant or the claimants and the defendant. Now, of those roughly 2,700, to date, the defendant has provided around 478, which it has itself picked and chosen to provide to us. And now, even as a starting point, we say that that is essentially a cherry-picking exercise. They have chosen which calls they are going to give us, and they have given them to us, and there are a whole raft of others which they have not.
So if we look if we look at call log schedule, this is under 1067, the page number. We can see a highlighted call details with certain numbers.
Yes, so the highlighted ones are ones which
2016 and 2020.
Yes, so that the highlighted ones are ones which have been produced, and the ones which aren't highlighted have not been produced. So all of these, as we understand it, are voice recordings. You can see in the top left it says voice recording index.
Yeah.
And the ones highlighted in green, the highlighting, I think, has been added by my solicitors to show which ones have been provided. And so all of the non-highlighted recordings have not yet been produced.
So is this your list, Mr. Note? The client list?
It's based on a list which was provided to us by the defendant earlier in the proceedings, which we then highlighted to show which have not been produced. So I'll be corrected if I'm wrong, but my understanding is that this list was in its original form compiled by the defendant to show all of the recordings that it holds of calls between the defendant and the claimants. And it has chosen to provide us with the ones in green, but not the ones that aren't highlighted. And
yes,
and so, yeah. And there are a number of points. The first is that although the defendant has agreed to provide some records to date, in addition to the ones it has already provided, a small number, even there has been confusion, and not all of the calls have been provided, even that they've agreed to provide. And one can see the simplest way to see that is in Mr. Singh's evidence on page 976 of the same bundle.
yes.
So at 976 of the bundle, at paragraph 46, the defendant agreed to produce certain recordings that were highlighted in the claimant's request. So the claimant had identified certain specific recordings. But as Mr. Singh explains, the highlighted recordings were those identified under paragraph 46.2. There were calls held with Archana Sawhney on the 24th of August 2016, calls held on the 13th of June 2018, calls held with Chij Sawhney and Gaurav Bhatnagar on 11th of March 2020, and calls held on 13th of March 2020. The defendant then provided 15 additional recordings in relation to those, but mentioned that some of them were corrupt, but the file names that were provided didn't identify any dates or times or participants, and there was no index provided. And 2 of the recordings didn't appear to contain any data. And as Mr. Singh explains at 46.4, we considered those recordings. No call recording at all has been provided in relation to the 24th of August recording. Now, in fairness, the defendant has suggested that it will undertake a further search for that recording. One of the call recordings in relation to the 13th of June appears to have been provided, but not any others. And in particular, 46.4.3, the call held between Mr. Sawhney and Gaurav Bhatnagar on the 11th of March 2020 has not been provided. Now, that is relevant because the defendant's own records suggests that that call both exists and was over 32 minutes long. And we can see that in the following manner. We go to page 1102, 1102 in the main bundle. Towards the bottom of that list, at number 2691, there is a call recorded on the 11th of March, 32 minutes, Gaurav Bhatnagar and Mr. Sawhney, and a third number at 4:46 p.m. And we know that the defendant has at some stage been able to assess the content of that call, because in June 2021, it sent us a letter, which is at 1105. And on the second page of that letter, it refers to the call of March 11th, 2020 at 4:46 p.m., which is the one we were looking at, We're in the process of making the details of the voice recording available to you. However, the content of the call is summarized in the related email correspondence. So the defendant must have been able to access the calls to be able to assure itself that it was in fact summarized in the related email correspondence. But the defendant's position now is that it cannot locate the call, or that the call only lasted 8 minutes. And we can see that from Ms. Jabala's evidence at page 1155. At 34.4, where it is said the defendant has produced 2 recordings dated 11th of March. He's not been able to locate the final recording, but is endeavouring to do so. The court should note that the duration column is in some cases incorrect. For example, it states that the call with Gaurav and Kishti was 32 minutes long. The correct duration is 8 minutes. Not clear how they know that if they don't have the recording. So that's an example of the discrepancies, even amongst those recordings that they have agreed to provide. But in my submission, they should provide the balance of the recordings in any event for these reasons. Firstly, to the extent that the defendant says that it has destroyed those recordings that pre-exist August 2016, pursuant to a data retention policy, we haven't seen that data retention policy. And the absence of those recordings is, in my submission, surprising given the existence of a complaint by the claimants in 2016, to which I'll come in relation to the next request, and COB Rule 3.6, which we saw, which requires the defendant to keep records relating to any suitability assessment for at least 6 years from the end of the client relationship, which would be from 2020 at the earliest. So unless none of those calls, or I should say none of those recordings related to assessments carried out by the bank, then on the face of it, they ought to have been kept. Now, a point is taken that the request is too broad because we are seeking all of the recordings and not specific recordings. But in my submission, it would be both unjust and unrealistic to expect the claimants at a distance of time of around a decade or more to be able to recall and identify specific telephone calls over a decade-long period, particularly in circumstances where the defendant has access to all of those recordings and can and has pick and choose which of them it produces. And in my submission, this goes to the overriding objective of putting the parties on an equal playing field. We shouldn't have to rely on the defendant to tell us which recordings are relevant, where the recordings can readily be provided, and we can assess that for ourselves. And it should go without saying, but I think it needs to be said, that contemporaneous records of the parties' communications by telephone are likely to be highly material to the key issues in this case. It's not likely that the majority of these calls related to social niceties. They were likely related to business that was being conducted with the bank. But to give a specific reason why, in addition, it is apparent that the contact notes on which the defendant relies, in certain instances, have discrepancies. Now, obviously, I would have explored those if we were pressing our application in relation to the contact notes. But to give an example that relates specifically to the telephone call recordings, just actually find it in my note because it's in a different place. Yes, so in a contact note, a particular contact note that we can see at page 1538 of the main bundle, tab E6. This is we can see at the top, trade ref number, IRS trade, and then below that, reason/purpose of trade, VI details, 1335 today from extension 20122, spoke to the client and gives a number. And then the trade date, 13th of June 2018. So if we just recall that time, 1335 on the 13th of June, and we can see that call recording in a call list at 1081. If one looks down the list to number 1092 in that schedule, we can see same date, 13th of June, same time, 1:35, and 45-second call duration. So we know there was a call and a voice recording on that date. But having reviewed that call, as Mr. Singh notes, and we can see this at 2362, paragraph 16.3.4, the call appears to have nothing whatsoever to do with an IRS trade. And Mr. Singh has there given a transcript of what appears on that call, and it appears to have nothing to do with an IRS trade. And so we've seen two examples, one of a call recording which has been agreed to be given, but appears to be 32 minutes long, but the defendant says 8 minutes long, but also says that it can't find it. Here, a call which we have been provided with, but which doesn't relate to or appear to back up how it is recorded in the contact notes. And in my submission, in those circumstances, it's only fair and reasonable that the defendant provides all of these recordings. And it doesn't appear that this would impose any particular burden on the defendant, because it has, as we can see from the list, already compiled a list of what these recordings are. And presumably in order to do that, it knows where the recordings are and can provide them in an appropriate form, as it has done with the limited number it has compiled to date. And so we do say that for all of those reasons, the calls should be provided. And then finally, in relation to the discrete requests, is request 40, which one can see at B/4/457. And these are request 40, internal communications relating to the complaint raised by the claimants in 2016. And the defendant's principal objection is that the request lacks specific relevance or materiality, because the complaint related mainly to the level of fees being charged by the bank, and not, for example, to the suitability of the products that were being sold to him. But in my submission, that is not a correct characterization of the complaint. And as we will see, these documents that are being sought are plainly material and relevant. And importantly, although the complaint did also relate to other matters, we can see that the defendant itself understood the complaint to relate to the defendant having introduced the claimants to complex trades. And we can see that from the relevant contemporaneous emails. And it's in a chain, so we have to start from the bottom up. So if we start at page 1144 in the bundle, the main bundle, we have there a email from Mr. Sawhney to a Mr. Rajan Seagal. So, dear Mr. Seagal, it was nice meeting you and other members of Credit Suisse at your bank in Dubai. The purpose of our meeting was to find a way forward / solution to salvage our portfolio. As you're aware, we have suffered huge losses due to FX/gold trading with CS. We're now working towards meeting all our obligations. And then the last sentence in that paragraph, we have shared with you the reasons what has led us to these losses. And if we scroll upwards in the chain, because it goes to read it upwards, we then switch to internal emails within the defendant. We see one from Mr. Rajan saying, is this logged as a complaint? Could you please draft a response for me compliant with our policy? We then scroll up to the next page, the top 1142. We discussed the below with Jabu around if we should treat the below as a complaint. To help us to confirm, do you have further details on what the client refers to where they state we've shared with you the reasons what has led us to these losses? Do you have details on what the client stated those reasons to be? He then chases for that on the next page, and then we get the answer at the bottom of page 1140, where Mr. Prashant says the client was referring to the meeting with Raj, Promit, Achana and me held in our office on 26 September. The client stated that he was introduced by the bank to FX trading and has also been advised by us on FX and other advisory portfolio holdings, and hence holds us responsible for losses as well. And they mentioned him that as per our understanding, he's a sophisticated client and has taken his own decisions. Then over the page again to 1139, we've discussed this, and the view is that we should treat this as a complaint and follow the standard process to send an acknowledgement and investigate to formally respond. And again, at the top of the page, again, be construed as a complaint. And then if we go up to 1134, so scrolling up quite a way now, a lot of chasing until we get to an email near the top of the page from a Miss Misha Myers. What's the status here? And then the response above on the next page, this is under review with compliance. And then finally, in relation to the compliance element, if we go to 1132, we can see in the second email on the page, at this stage, compliance in Dubai, so not Switzerland, is still reviewing the complaint, and it will take some time as it is not quite straightforward. I followed up with them yesterday and hope to receive initial feedback from them by the end of this week. And so, although the word suitability, for example, is not used in that chain, it is clear that the complaint directly concerns a key issue in the case, namely whether or not it was appropriate to recommend certain products to the claimants. And it's also clear that the defendant itself considered it as such and considered it not straightforward, and that its internal compliance team was looking at it. And in my submission, it is plain that an internal determination or review by the defendant of its own actions as regards suitability and or sophistication and or the recommendation of products is plainly relevant to this dispute. And in that regard, it is in my submission telling that the defendant doesn't say in this regard that this is not relevant material. And the skeleton argument is carefully worded here. My learned friend saying at paragraph 102, there is no reason why its internal communications concerning that complaint would touch on issues of suitability. There is therefore no reason why such documents would be material. What is not said is that it's not material. And so in my submission, this is very far from a fishing expedition, which is how the defendant seeks to characterize it. The request seeks a specific class of documents relating to a single complaint in 2016 in relation to material issues which are already pleaded. And in my submission, that is an appropriate basis for the defendant to be ordered to produce these documents. So Your Honour, mindful of the time, those are my submissions in relation to the balance of the document production application. Obviously, I reserve my position in relation to the contact notes, subject to the conversation that we will try to have with the other side over the break.
Right, Mr. Shafji.
Very good, thank you, Your Excellency. I'll start with the strikeouts application, and if we could go back to have a look at the pleading that my learned friend takes issue with. So that was A tab 2, page 237 of the main hearing bundle.
Paragraph 8(4), yes, 1(8), right?
Yeah.
The red font, yeah.
So the first point to note is actually if we start at 84.8.1, that relates, yes, that. So before we get to A, actually, that which is the amendment. If you the previous paragraph, which is in black,
I can see.
So that is an allegation there that that we did have reasonable grounds to conclude that the claimants appeared to have sufficient experience and understanding of the relevant financial markets, products, or transactions, and any associated risks to be categorized as professional clients. So the starting point is that our case is that these were properly classified clients on the information that we had. My learned friend doesn't take issue with that. He accepts that's an issue in the case. Then the next paragraph develops this, and it says that we were aware that the claimants had been categorized by other financial institutions as professional clients. And it says that we were entitled to and did take that into account when determining whether the claimant should be classified as professional clients by us. Now, in relation to that paragraph 84.8.1a, my learned friend does not seek to strike out that allegation. He accepts that that is a properly arguable allegation, and there is no issue between us that that will form one of the matters for this court to determine at trial. So just pausing for a moment there, before we even get into the area of controversy, it will be an issue for the trial of this matter how other institutions classified the claimants, whether we took that into account, and whether we were entitled to. And all of that is going to be issues for trial that this court will need to consider. And they're not, my learned friend is quite rightly not seeking to strike out any of those points. The paragraph that he then takes issue with actually builds on this argument, and this is then B. And we say that as a matter of law and fact, whether an authorised firm had reasonable grounds to conclude that a person had sufficient experience and understanding to be classified as a professional client is informed by how other financial institutions had classified that person at the time and the grounds on which they did so. So we say this sort of stage one is this is something we were aware of, we took it into account, and that we were entitled to do so. That is in the proceedings. We then develop that argument by saying that is something that goes to the applicable test. Now, even if my learned friend struck out paragraph B, essentially the question of whether we were entitled to rely on their classification by other clients would still be an issue under A. So his strikeout is actually quite a subtle shaving down of the case, on primarily a question of law, but it wouldn't actually lead substantively to a different inquiry at trial. Now, perhaps because of that problem, in my learned friend's submissions, he tried to diminish the importance of paragraph A. We rather glossed over it. And at one point, he said to you that there was no contemporaneous evidence that we had relied on classifications by other banks. Now, with respect, that sort of concept is a little bit of a trap for the court, because, of course, at this stage, the court cannot decide that question of fact. It ultimately, we advance a positive case that this is something we took into account. And at trial, we will have to look at the evidence available to see whether that case could be sustained. So with respect, it's not good enough, my learned friend, to say, well, there's no contemporaneous evidence of that, because this is not the stage of the case where you ascertain that. And he's not even trying to strike out this point. And just to develop that argument, if we now go forward in the bundle to our further information on that plea, that's at C tab 6, page 583. So that's the main bundle, C tab 6, page 583.
Give me the page number again.
C tab
Yeah.
6, page 583.
Yes.
And this is further information in relation to that paragraph A. And they ask us to identify the other financial institutions which we were aware of had classified the claimants as professional clients. And we say this, we say pending document production, the defendant is not able to list all other financial institutions which categorize the claimants as professional clients. The defendant, and as relevant its predecessor, was aware that other financial institutions generally had categorized the claimants, whether individually or both, as professional clients. So we say this is something we knew generally, and then we go on to say further, the defendant and its predecessor was aware that the claimants were clients of Kotak Mahindra Financial Services Limited. That financial institution did not have a retail endorsement from the DFSA and categorized the claimants as professional clients. So we then give an example of one institution that we were aware of, and that institution didn't have a retail endorsement, and so must have categorized them as professional clients. Now, we also deal with this in our evidence, and I'd like you to have a look at that. So this is I tab 2, page 2494. And this is the witness statement of Mrs. Kalayapan. Actually, I would be grateful if you could turn this up. So this is I tab 2, page 24. In fact, we'll start at 2492, and then I'll take you forward on that.
Yes.
You got that. Very good. So you may have seen Ms. Kalayapan referenced across the pleadings. She was a client advisor at Credit Suisse during the relevant period. I just want to pick up some other points while we're here from her statement to save me having to go back to it. But she deals in quite a lot of detail in her statement with the claimant's knowledge, experience, understanding, and appetite to risk. And if you look at the next page, page 2493, at paragraph 5, she explains that she's worked in banking for almost 30 years, and then she gives her work history. And in paragraph, just to give you an idea of her seniority and importance, when she was working for ABN AMRO, at ADCB Bank, which is part of ABN AMRO, she had a team of 160 people working under her. So she was a senior person, obviously with a very significant amount of experience. She then says at paragraph 8, last sentence, that when she took over the claimant's client relationship. She says she became aware that they had a lot of accounts with a lot of banks, and I believe this to be something to be proud of. Sorry, and I believe that they considered this to be something to be proud of. So she was aware of other accounts with other banks, and she thought that was something they were proud of. She then goes on to deal with the fact that they both invested together. And then I just want to look at 10 and 11. So at 10, she says, as I understand it, the claimant's case is that they were naive investors whose investment objective was to ensure stability and safety of their investments, but were misled by the bank into investing into high-risk products that were not suitable for them. This is not correct. The Sawhneys are, in my view, the most sophisticated investors I have ever managed. I just want to pause there for a moment. She's obviously had 30 years experience in the industry, a very senior person leading a team of 160 people. And these are the most sophisticated clients she says she's ever come across. Now, she goes on to explain that Mr. Sawhney is a chartered accountant, graduated from a top institution. She then goes on to say, by the time the claimants opened an account with CL, that's the predecessor, they had already been investing in complex financial products for over 15 years. As set out, they had investment accounts with numerous finance institutions. Indeed, during our relationship, the claimants made reference to at least 12 accounts, and then she lists them: Kotak Mahindra, Bank of Singapore, Bank Sarasin Alpin, Mashreq, ADCB, ICIC, ABN AMRO, ANZ, LLB, UBS, DBS, and Citibank. And then she says, many of these banks had, I believe, provided financial services to the claimants in or from the DIFC and had categorized the claimants as professional clients. For example, the Bank of Singapore, Bank Sarasin Alpin, UBS, and DBS fall into this category. So again, we can see from the factual material the court has already got that the bank was aware of other accounts. We've advanced a positive case that we were aware of their classification by other institutions, and all of that is going to form part of trial. Now, when my learned friend said there wasn't a contemporaneous record of classifications, well, there is a contemporaneous record that these clients had banks with some of those other institutions, and that's, we won't turn it up, but that's in the bundle at D, tab 3, page 677. So that just explains why these points are factual issues that are in play in any event. And Your Excellency might remember from the judgment that you gave us in 2022 on a previous strikeout application that actually Your Excellency referred to this classification point and the fact that we said that some of the other banks had classified these clients as professional clients. And that's because even back then, it was known that that was going to be an issue for this trial. So those are the factual points. Now, I wanted to move on, deal briefly with my learned friend's analysis of the law on this. And by that, can we go back to the conduct of business rules, which are in the supplemental bundle? And we'll look at the supplemental bundle, tab A, page 14, page 273.
Yes, I got it.
And this is these are part of the rules which explain the analysis that a firm must take into account when assessing whether or not to take on a client as a professional client. Now, I don't believe that this was developed by my learned friend, but if we just actually look at the final item for starters, so 2.5.11G, the final item is any other matters which the authorised firm considers relevant. So one of the factors that a firm is allowed to take into account is what the firm thinks is relevant. And if the firm thinks it's relevant that a client has been classified as a professional client generally or specifically by other institutions, that is at least arguably a factor that a firm could take into account. Now, the classification by other institutions also goes to another of these other items. It goes to A, the person's knowledge and understanding of the market, products and risks. It goes to B, the length of time the person has participated, the frequency of their dealings, and the extent to which they've relied on financial advice from financial institutions. And can I just say that that reference there to financial institutions, that must mean other financial institutions, or at least include other financial institutions. It's not limited to this particular bank, and that's obvious. If you get a really experienced customer through the door who's traded as a professional investor with many other institutions for 20 years in the most sophisticated products, of course that's going to be relevant in deciding whether or not you should classify them as professional. And it also goes to C, which is the size and nature of transactions that have been undertaken by the person in the relevant financial markets. So the first point is that these points of classification by other institutions feed directly into this DFSA rulebook on how a firm should appoint classification. So that's the first point. If we then go back 2 pages to Rule 2.3.2, then the next stage of the analysis at B is it says subject to 2 appears on reasonable grounds to the authorised firm to have sufficient experience and understanding of the relevant financial markets, etc. Now, I just want to pause for a moment to look at the words reasonable grounds. Now, there's a dispute between me and my learned friend on this. We say that when the court comes to look at the question of whether we had reasonable grounds, it can look at what other financial institutions did as well in relation to these same clients. And we say there's some real logic to that. We know that there were 12 other accounts. Just say for a moment that 12 other institutions classified these clients as professional on the same basis. Is it necessarily the case that this court will decide that that is wholly irrelevant? And we said at this stage, the court shouldn't come to that view. We're at an interlocutory stage. You don't have the full evidence. You don't have expert evidence. You don't have the full submissions. It is possible, I'm not putting it higher than that, it's possible that the court might say that in assessing whether we had reasonable grounds, it would be relevant what the other institutions did. Now, my learned friend accepted, I think, when his submissions, that we might actually have expert evidence on classification at trial. And I'm not yet forming a view as to whether that will or will not necessary, but he seems to concede that that is at least possible. Now, again, what are those experts going to opine on? They're going to opine on the practice by other institutions across the market and how they classify people. And of course, it would be relevant to that evidence if, let's say, 12 other institutions had classified these clients as professionals. So again, those are exactly the issues that court will consider at trial. Now, we say that now would be an inappropriate moment for the court to give a definitive ruling on the scope of these conduct of business rules. And I say that because this is an interlocutory hearing. My learned friend accepted during the course of his submissions that we were time limited. He was having to curtail his submissions because of the timing. So am I. Your Excellency has not heard full evidence, full expert evidence, and full submissions on these points. And yet a ruling by this court, this will be the first ruling of this court on the scope of this classification. So in the Karafi case didn't grapple with this point. This would be the first ruling of this court. The whole of all of the banking industry in the DIFC would look very hard and would no doubt be influenced by what Your Excellency had to say on this. And every bank in the DIFC that takes on professional clients may have to react. If Your Excellency suddenly said, well, you can't take into account something, or you had to do something else, that may lead to the reclassification or re-review of thousands, tens of thousands, maybe more, hundreds of thousands of clients by banks in this market. And of course, at trial, Your Excellency would have heard all of the evidence, all of the expert evidence, and all of the submissions, and Your Excellency might want to give that ruling. But we say that it actually puts the court in an unfair position, trying to force its hand at this stage. by shutting us out of these points. And that's what my learned friends are trying to do. They're trying to say you are not allowed to argue that you were entitled to take into account these clients' classifications by other institutions. And we say that on the face of the rules, it's obviously available to us to run that argument. We were entitled to take into account other relevant matters, and that the court shouldn't shut us out from doing that now. So that's the point about the interpretation. We'd encourage you to resist the temptation.
So, I'm not sure I understand your position. If I understand your position correctly, is it too mature to decide this case and must be left up to trial? So I should not attempt to, I said, resolve this question now, or you suggesting that, well, the test of reasonableness, and then, as you said, the meaning in some other article of this regulatory law means that you can rely on another bank conduct when it comes to the classification of the client. So the rules allows you to do that.
Yes.
So on this basis, then the court should decide that to refuse the strike application and answer the question that the bank could rely on another financial institution conduct or listing or classification in addition to another factors.
Yeah, well, so Your Excellency is absolutely right. I'm actually advancing both points, but on my first point is we were allowed to do this under the rules, and I've showed you that list of criteria, the analysis that we're allowed to carry out, and I say that we fall in the case of any other matters which the authorised firm considered relevant. So that's the first point. That's as to actually the information we had about what they were classified. And then the more general point, so that's specifically what we had. And then the more general point, when you come to reasonableness, you can look what other institutions did, even the ones that we didn't have at the time. That's the second point. And then my third point is, at this strikeout stage, all Your Excellency needs to do, we say, is refuse the strikeout application. So we say you don't actually need to decide this question. And we would also say that, and this is, Your Excellency will know this from the authorities, on a significant issue, which will be a key question at trial, the court ought not to decide it at an interlocutory stage. You ought to save it for trial. So you can simply say, I'm refusing the strikeout application. The claimants can run this argument at trial, and at trial I will have the full benefit of the evidence, factual evidence, expert evidence, and submissions. And then I will be able to decide this in the round, having all of the information.
I see. So the third point is at your alternative, that deferring the question is to the trial.
Yes.
But
yes.
this, yeah. But if this question is not answered earlier, so that would keep the situation kind of loosey, especially when it's come to the production of document related to the same questions, and maybe a lot of other evidence related to this.
Well, I'm going to come to the production of documents. My learned friend quite fairly said that even if you won on this point, it wouldn't remove my application, and he's right about that. And in fact, when we go through the 15 categories that I'm after, not one of those categories depends on this strikeout. So actually there is no shortcut when it comes to document production because of this point. So, and I'll take you to that. Can I just make one other point that this issue goes to? So my learned friend tries to draw a distinction between what we knew, which he's not trying to strike out, and what we didn't know. Now, I've explained to you that even what we didn't know is relevant to the court's exercise. It's also relevant to whether or not the court will grant relief against us under Article 65. So one of the claims against us is a claim for breach of the regulatory law under Article 65. And under Article 65, subsection 5, the court has the power to refuse relief, even when the legal basis of a breach is made out. The court has the power to refuse the relief, and it does so. I'll just read it to you. Where the court thinks it's fair and just in the circumstances to do so. So the test is fair and just in the circumstances. And we say that in deciding whether to refuse relief at trial, your Excellency will want to take into account what these other institutions did. So again, taking my hypothesis, if we categorize them as professional clients based on the information given to us, and you find that 12 other institutions had done the same thing on the same information, you might well say, well, actually, the bank was acting reasonably, because this is exactly what, at the time in the market in 2012 or 2015, this is how banks were categorizing clients like this. So there is a world in which your Excellency actually says it's relevant to Article 65. So that's another reason why this comes in at that stage. And again, my learned friend's not trying to strike out my case on Article 65(5). So the point still comes back in there. So we say we say we're right about this, but I also say you don't need to decide it now, and you can come back to this at trial. Now the reason it makes no difference at all on document production, I think the next step actually is to look at our document production application, and then I'll come to my learned friend's application. So I just wanted to start with some general points on document production, and then I want to develop some specific factual questions for your Excellency. These are basic points, and your Excellency will know them, but it's just useful to reset the discussion because I think my learned friends have lost sight of this. Obviously, the purpose of document production is to make sure that the court has before it the correct documents in order to decide all of the issues in the case. It's the court that's going to have to make a decision in this matter, and it's the court that needs to have a complete picture, not a partial one. That's my first point. Now, my second point is that the document production is defined by what is in dispute between the parties, not how one party puts its case. And a lot of what my learned friend says about document production, in terms of his resistance of our documents that we seek, is on how he sees the world. Now, that's his case, but that's not my case. And the purpose of document production is to make sure that the right documents before the court so that the court can assess both parties' cases. So document production should be given if material is relevant to one of the parties' cases. And that's because the court can't resolve at this stage which party is right on that. That's the job for trial. And then my third point is that cases like this is effectively the first mis-selling case in the DIFC since the Karafi case. The Karafi case, which it was now a while ago, there are people all around the room, including myself, who appeared in that case. But the issues in that case were quite different to this case. I mean, it's striking that neither party cited the Karafi decision in its skeleton arguments for this hearing. This case will look at issues that were never considered in Karafi, and this will be an important case for the market. And we say that in taking this case forward, the court should be striking a balance between the interests of the claimants as investors and the interests of the bank. And again, we think the claimants have rather lost sight of this. They spend a lot of time talking about the imbalance between the parties. They say, oh, you're a big bank, so you should be required to do X. But we are private investors, and so we should not be required to do something similar. And that just doesn't bear scrutiny. First of all, because the claimants are, even on the evidence we have, high net worth individuals. They clearly had some investment activity elsewhere. They had a staff of people working for them. My learned friend tries to give the impression that they're elderly. There's quite a few references in the skeleton argument to them being of advanced age. In 2012, when we took them on as clients, they were 52 and 49. Now, this may be a generational thing, but certainly from where I'm looking at the world, 52 and 49 is not old. So they're not old clients. They were in the sort of prime of their business life when the events relevant to this case happened. And they're obviously well resourced. I mean, my learned friend said earlier on how they'll get an IT expert to have a look at what we say about our document production. So they've got the resources available to them when they need it. They're on their third law firm. there's no reason to think that they are resourced in a way that means that they need to be treated differently. And we say that the court must treat both sides fairly. And the critical point is we need to have a fair trial of this case. So the bank shouldn't be at a disadvantage simply because it's a bank. So those are my preliminary points. I actually just now want to dive into some of the factual and legal points because they help frame our document production requests. And just turning to the factual points, for today's purposes, it's important to note that there's going to be some factual issues about the claimant's characteristics, which will be critical at trial. And I'm just going to list those characteristics for you. They are the claimant's knowledge of the investments and the markets, their experience, which is connected to knowledge but different, their understanding, which again is connected to knowledge and experience but different, their appetite for taking on risk, their tolerance to risk, their ability to withstand risk. That's the fourth point. And then fifthly, their classification by other institutions. And all of those characteristics are issues at trial. Even if my learned friend strikes out paragraph B, all of those points are still in play for this case. And we say that, I mean, Your Excellency said it at the beginning, that that's a really big part of what this case is about. You know, who were these people? Were they unsophisticated investors who really had no understanding of this, completely bewildered by it? Or, as Ms. Calipan said, are they the most sophisticated investors that she's ever met? Your Excellency will have to grapple with that central question. Now, those 5 characteristics are relevant to 3 factual areas the court will need to determine at trial. Now, the first factual area is that in different parts of the case, those characteristics are in dispute. And if you look at the pleadings, I'm going to show the pleadings to you in a minute, these characteristics come up all the time at lots of different points in the chronology, and none of that is sought to be struck out. So that's my first point. These characteristics come up in the pleadings. The second point is that these characteristics go to the dispute over what was said at oral meetings. Now, there are lots of oral meetings between the parties. There are arguments over whether there's a satisfactory record of all of those meetings. There are arguments about things that happened at particular meetings where you will have to decide that on the basis of witness evidence at trial. And those characteristics will help inform what was likely said at those meetings. So, for example, we say at those meetings that they told us that they were sophisticated and experienced, and that we believed on the basis of those discussions that they had a good understanding and that they had an appetite to risk. And they said something quite different. They say, oh no, at that meeting, we told you we were unsophisticated and inexperienced. Now, the truth of the position, so sorry, I don't think we're on fire. I think this is just a test. No, it stopped. I'm so sorry about that. So in terms of looking at what happened at those meetings, that will be an issue for the court to resolve at trial. There's a dispute about whether they told us that they were unsophisticated or whether they told us they were sophisticated. What actually happened at those meetings will be influenced by what the true position was. So if I'm right, and we can see from their dealings with, for example, those 12 other institutions, that they were highly sophisticated trading in complex products, then it's much more likely at that meeting that they said they were sophisticated. And if they told us that they were unsophisticated in light of that, that would actually be a lie, and that would be something in itself we could rely on. So Your Excellency is going to have to grapple with actually what the truth is, and the truth will help inform deciding then what happens at those meetings. And it's not just knowledge and experience we're talking about, because they feed into understanding. All of these factors feed into risk, and obviously classification goes into all of those 4 prior issues. So all of those 5 characteristics are going to be relevant to your assessment of what happened at these meetings. That's my second point. My third point is that the claimants say that our record keeping, where we record that they were sophisticated investors, was wrong. Now, the burden is on my learned friend to prove that they were wrong. And the documents that go to the claimants, 5 characteristics, will go to that question of whether our records were wrong. So they have to prove it. We're entitled to try and disprove it. And these documents go to that. So those are the 3 factual areas that the court will have to grapple with. And I just want to show you briefly on the face of the pleadings how these come up time and time again. I'm not going to take you to all the references. I'm just going to take you to a few of them. So if we can start with the, we might just start actually with our amended defence. So this is at A tab 6, page 193, please.
What bundle is that?
This is the main bundle. Sorry, I'm so sorry.
Remember, yeah. What's the reference again?
A tab 6, page 193. This is our defence.
I'm afraid I got wrong reference, so...
Oh, I'm so sorry. I'll try again. This is the main bundle, tab A, tab 6, page 193.
Yes, I got it now, yes.
Great, very good. So this is the beginning of our defence, and we will just capture in a few paragraphs here what this case is about. We say at the beginning of 2, as the defendant understands, the primary allegations made in the amended predictive claim are that the claimants were unsophisticated investors who were incorrectly classified the defendant as professional clients and then negligently advised to invest in products that were unsuitable for their modest risk appetite, and as a result of which they have suffered loss. These allegations are unfounded and false. The true position is as follows. The claimants are highly sophisticated investors who, prior to their involvement with the defendant, had already been investing for at least 15 years, including in complex and high-risk products such as derivatives. The claimants are prolific investors and had accounts with or invested with numerous financial institutions over the years. During or around the defendant's relationship with the claimant, these included, we then list the institutions, and we say many of these institutions provided financial services to the claimants in or from the DIFC and categorised the claimants as professional clients. To the best of the defendant's knowledge, the claimants have not suggested that their classification at any of these other institutions was incorrect. So that, in a nutshell, is what we say the case was about. We obviously go on to develop some other points. And then if we just move forward to the next tab, so we go forward to tab A7, page 283.
The amended reply to this.
Yes, exactly. Paragraph 2, save insofar as the matters pleaded in the amended offence consist of admissions or is expressly admitted or not admitted herein, the claimants deny and join issue with each and every allegation in the amended defence. So unless they admit it or they non-admit it, everything is in dispute, including what I've just shown you. And then specifically for that paragraph, they say at 3, the claimants do not plead specifically to the allegations set out in the summary at paragraph 2, which for the avoidance of doubt are denied. So there can be no doubt that they don't accept those allegations and those are in dispute. And we say that that's at the heart of our case. Now, it's also at the heart of the way that the claimants put their case. I mean, frankly, it's at the heart of our defence, and so it's an issue for trial, and that's the end of the matter. But it's also even the way that they put their case. So let's go back to have a look at their particular claim. And that is at A tab 2, page 20. Do you have that?
Yeah, I got it.
Very good. So this is the claimant's particulars of claim. I'm just going to pick out a few paragraphs. So this is how they start with the facts giving rise to the claims. They have a section entitled The Opening of the Relationship, and then they say at 7.1, Alka, who's the second claimant, had no knowledge and experience of any financial products beyond current and savings bank accounts. And then they go on to say that we had very limited interaction with them. And then at 7.2, they say that the first claimant's previous experience of financial products was limited to simple instruments such as bank deposits, bonds, perpetuals, and simple products that ensured a steady return on investment with a low risk exposure. And if we go then forward to 8, they say their investment objective was never to invest in high risk products. And then again, can we go forward to page 24, please? Now, I'm not going to take you through. Sorry. Actually, sorry. I know I will go to page 24. I'm not going to take you through every reference because there are many. But what one can see from the pleading is that there were numerous meetings, phone calls before the period that phone records exist, where there were discussions about experience and understanding. And the court doesn't have a contemporaneous record of those. The court is going to have to decide that on the documentary and witness evidence that you have. Now, I'm going to take you to a few particularly significant areas of the case where the claimant actually advanced a positive case on knowledge and experience, but this is not all of it. This is just a snapshot. So, for example, I'm going to take you to a paragraph 20 on page 24, which is a particular form that we have, the knowledge and experience form from 2012. Now, this is a form that lists out the claimant's experience. It lists them out as being experienced investors. And I'll give you the reference to the form, but I think in light of the time, I won't take you to it. It's at D tab 3, page 713. Now, the claimants say that when they signed this form, the form was blank, and they say that the information then subsequently completed on it was false. And they say that in this part of their pleading at paragraph 20.4, and if we just go over the page, 20.4.2 at page 25. So they say that the form incorrectly records both of the claimants as having experience and knowledge in a number of product classes and risk aspects, when in fact Alka had no knowledge or experience of any of the tech product classes and risk aspects, and that Sanjeev neither had knowledge or experience of hedge funds, private equity swaps, derivatives, OTC products, etc. So this is just one of a number of forms where our forms record them having experience, and they say, no, that is not true. Now, the only way the court is going to be able to resolve whether these forms were filled in correctly is by assessing the truth. What actually were these clients' experience? And that truth will then inform the court's assessment of what was said in these meetings. Now, there are many, many issues on many of these different forms, and they all have a very similar sort of dispute, that the claimants say that the information on the form was false, that it didn't reflect their true experience, and they say that the forms were completed after they signed them. And we don't accept that. That's disputed on the face of our defence. We say that they were completed when they signed them and that this did reflect their true experience. So that was one, the 2012 K&E form. There's another one on page 25, which is the client profile, which is dealt with at paragraph 21. It's exactly the same sorts of arguments. Then again, another form is the 2014 K&E form. That's at page 31 of the pleading. And again, they say it was blank when they were filled in. They say the information completed was false. we say that it was completed when they signed it and the information set out is true. Now, on top of these many documents where they say that we falsely recorded their experience, there are many occasions also where there were oral discussions between the parties, and I just want to show you some of those. So this is in our defence at A tab 6, page 209.
Yes, I mean.
So we say just at paragraph 48, we say that there were frequent meetings between Shanti and the claimants at their office in Dubai, at which the defendant would discuss the claimant's investment. So we say in many of these discussions, there isn't a record of all of those, and obviously not telephone recordings going that far back. Then if we go forward to page 211, and it's 51.5. Now, the claimants alleged that they said at one of these meetings that the forms were incorrect for them, and that's 51.5.1, and we say that's not true. It's denied that they told us that the 2014 KNE form was not correct, whether at a meeting in April or May 2016 or otherwise. And then if you go forward to 51.5.3, we say there were numerous discussions with the claimants over the years about investments which related to their understanding and knowledge of investments in the financial markets. They were regularly given the opportunity to provide information which related to the information in the 2014 knowledge and experience form. So again, this is going to be something that the court looks at trial. All these meetings, lots of discussions about knowledge and experience, but what was said, what is the truth of what happened? And again, we say that's obviously going to be informed by the reality of the experience, the claimant's true profile on those 5 characteristics I identified. That just shows you how across these pleadings there are lots of issues about knowledge and experience, and this is on the claimant's own case. And I've explained to you why those factual issues on those 5 characteristics go to 3 areas of factual inquiry for the court at trial. They also go to legal issues. Now, my learned friend has been forced into the position to say that all of these points about the claimant's true characteristics are legally irrelevant to the case. Now, that is quite a remarkable submission when one steps back. They just say it doesn't matter. The court doesn't need to ask about the true position. It should just proceed on the basis of whatever documents the bank now has 13 years after the event. And one only needs to pause for a moment to see what trap there would be for banks if that were the case. It would put process over form. So let's say, for example, that the bank had a server with the information on it and the server had crashed, or the backup tape had been corrupted. And so the bank couldn't produce the contemporaneous records. On my learned friend's analysis, you wouldn't have any regard to what the truth of the position was. You would simply say, well, I've got to look at the bank's records. The bank doesn't have records because they've been destroyed. And so the bank then has no defence to a claim for suitability or misclassification because you're not allowed to look at the true position. It's just an unreal position, and it will be a trap for every bank that operated in the DIFC. Now, my learned friend is wrong when he says that these factual matters have no bearing on the legal parts of the case, and they obviously do. And there are 3 areas where we say that they're relevant. Firstly, the true characteristics of the claimants is relevant to their classification. So if they were experienced, sophisticated investors with knowledge and understanding, had been classified by other institutions, those are all indications that we got the classification right. And the court may well take the view that we got the classification right because lots of other institutions had done the same thing on the basis of the same information. And the classification is in substantial part influenced by the claimant's personal characteristics. And my learned friend rather sort of gives this away in his skeleton argument. I won't turn it up, but I'll just read it to you. So in paragraph 9 of his skeleton argument, he says that his clients were not professional clients. And he says that's what, I'm quoting, what the claimants were given their levels of financial sophistication. So he
I would need really some clarification here. I mean, the case is, my understanding is that, so according to the bank's official classification forms, the clients are classified to be professional.
Correct.
The claimants are not happy with that, and they said that's either wrong or changed or made after signature. So the bank tried to prove, no, they are professional by many means. And the same time, the claimant wants to change for you at least, a settled fact that bank's official forms, they were classified as professionals, professional investors.
Yes.
They are open to a high risk transaction, and they've been taking many decisions by their own.
Yes.
So we have two different situations now. So the claimant is, first of all, rejecting the bank formal internal, let's say, forms and procedures by classifying this client out. But the client are not happy for you to stick to that form they have already signed.
Yes. Yes.
So this is a kind of contradictory, isn't it?
Well, it is, but I do accept that it is open to them to run these arguments for trial.
Yeah, I'm not saying they're not.
Yeah.
Yes, yeah.
Yeah, I agree with you. We will have to resolve at trial what the status of those documents are and what form they were in when they were filled out. And my submission to you is that when you're considering all of those issues, you will be influenced by what the truth was on what these claimants were actually doing. So my learned friend says you can look at their knowledge of experience, but you mustn't look, or you're not allowed to look at what they were doing elsewhere with other banks. He said it's completely irrelevant, but it just doesn't accord with common sense. It's obviously relevant.
I think the case is going at highest. It's irrelevant even what your form suggests.
Yes, he is saying that as well. That's correct. So but that's his case. I'm not asking you to decide his case today. That's his case. He will run it at trial. But all I'm saying is I want to run my case, and I want the documents to support my case. And those documents include documents going to the claimant's sophistication, experience, understanding, risk classification. And I was just making a point to you that my learned friend, when he talks about the classification in his skeleton argument, he does talk about the claimant's level of financial sophistication. And that seems to be acceptance on his part that the court's going to have to grapple with this. Were these clients actually, in truth, sophisticated clients or not? And of course, you're going to be assisted by that, by looking at their investment history with other institutions. So that's the first point. The second point is that when the court comes to assess suitability is actually determined by reference to what the client's actual characteristics were, not what the bank's documents say. And that is the state of the law. Now, my learned friend doesn't cite any of the authorities on suitability. But we say it's crystal clear. And in fact, one of the decisions we rely on is a decision of Justice Cook. But Justice Cook, when he was in his English commercial court days before he sat in the DIFC, and I just wanted to show you his decision in the Basma case, which is in the supplemental trial bundle at supplemental bundle tab B, tab 7. Page 430.
What's the page number for last time? Again.
Yeah, so
we're speaking about the main bundle, yeah?
Yeah, no, supplemental, please.
Supplemental.
Supplemental, tab B, tab 7, page 430.
Yeah, I can see Basma Suleiman versus Suisse.
Yes. So this is a decision of, as I said, Mr. Justice Cook, as he was then, now Justice Cook. So if we just take, it's the second sentence of paragraph 19. If an investment is in fact suitable for the client, then it ultimately does not matter if there have been failings in the process. Now that is the critical point. So what matters is, and this is the question for the court at trial, were these investments suitable for these claimants given their characteristics? It isn't a point about the process. If the bank failed to record the correct information, let's say the bank completely failed, there's no notes at all. That doesn't matter. That's a failure of the process. What matters is the substance. And that makes perfect sense, because it would be quite wrong for a bank to be on the hook for selling a product for it's unsuitable when the product actually was suitable, but the bank just didn't keep the right records. And that cuts through. My learned friend in his submissions and his skeleton spends a lot of time going through the rules, and they've underlined every time the rules refer to what the bank is meant to do. But that just ignores all the case law about how these rules are interpreted. And these cases are clear that it's the substance that matters, not the process. And again, at this stage, all I'm saying is that this is my case. He may disagree with that. He may try and persuade you at trial that you shouldn't follow Justice Cook and that you should do something different. And that may be his argument. But for today, that is how I put my case. So again, suitability is assessed by reference to the claimant's actual characteristics, and the court will need to ascertain that. And then the final legal area that this goes to is causation. So the bank's position is that the claimants regularly ignored their advice and went ahead with investments anyway. And in relation to the investments in dispute in this case, even if the claimants can find an investment which the bank recommended, but which they say that the bank ought to have recommended against, the court will then have to decide what the claimants would have done. So if we given the opposite advice, if we'd said this is unsuitable for you, what would they have done? And the court's going to have to examine the other trading that the claimants were doing elsewhere. That is the best indication of what they would have done. So if they were routinely buying these things from other institutions as professional clients without recommendations or against other people's advice, that's going to be highly material to the court assessing what they would have done if we'd given different advice. So for causation reasons, again, this points in. So those are three distinct legal areas where the client's actual characteristics will be a factor the court looks into. And so pulling all that together, it is no matter that my learned friend sees the world differently. He says, I'm wrong about all of that. You can't look at any of that. But now is not the time to ascertain that. We're going to have to ascertain that at trial. And even if the factual issues didn't have a direct ramification in the legal causes of action, that's how the claimants pleaded their case, and that's how I've pleaded my defence. These are the things that we want the court to look at trial. And sometimes parties plead things because they think it's important context, even though it doesn't directly bear on a cause of action. And that's fine. The court allows that. It's acceptable. And they haven't withdrawn their allegations on knowledge, experience, understanding, appetite to risk, and they haven't tried to strike out my defence on it. So they can't complain about the way the case is framed. So that brings me then into our document production requests. And I just wanted to make some preliminary points, and then we'll dive in to the categories. The first point is that there is a very different attitude when it comes to helping the court on document production as between the claimants and the defendants. So on the defendant side, they made 41 requests of us. We've been extremely accommodating. We've given over 1,000 contact notes. We gave them voluntarily. My learned friend accepted. We've given 500 phone calls. We've given countless other agreements, notifications, electronic documents, statements. We've given a vast amount of material, and we have done that without objection, acting as a responsible bank and helping our clients. And as I said, they made 41 requests. They're content with our position on 34. There are only 7 requests remaining. And actually, of those 7 requests, we've either provided documents or conducted searches for 4 of those requests. So out of the original 41, there are only 3 that we are just simply opposing. And that gives you a really good indication of how the bank has approached document production. It's done it in a sensible way. What about the claimants? Well, we made 15 requests of them. How many have they complied with? Not one. They oppose every single request. And in relation to, there's only one request where they say they were going to comply, but what they've given us just cannot be in compliance. And we, in relation to our 15 requests, as I understand it, we've only received one single piece of paper. And I will show you that piece of paper. Now, the requests that we make, the 15 requests we make, go to those 3 factual issues that I've identified, and also the 3 legal issues about the defendant's characteristics. And in setting our 15 requests, we have given very careful thought to these categories. We've tried to define them as narrowly as possible. And these are documents that we consider that we need fairly to present our defence. We say they're crucial to a fair trial. So the bank is not just a sort of blank. Sometimes in cases, one just sees a random list of things, but this is not what the bank's done. It's actually thought hard about what it needs, and is really tried to craft the categories as carefully as it can. Now, that all of the categories really revolve around, with a couple of exceptions, that most of them revolve around the claimant's financial records. And it shouldn't be hard for the claimants to find these financial records. The claimants have their own administrative staff. We plead that in paragraph 20.3 of our defence. And the claimants don't dispute that in their reply, paragraph 19.4 of their reply. So they were high net worth individuals, they had staff, and they likely have a file of their financial records, like we all do, at home or maybe in the office. And further, many of these records would have been sent to the claimants electronically. They have an email address that we've seen from the documents, so they could be found either on their emails or by searching their computer. So Your Excellency rather observed this at the start of the hearing. The amount of effort that has gone into resisting document production and the number of applications, the complexity of all of this, the money that's being spent by the claimants, when in fact to go and pull out their file of investments at home or in the office, how much effort would that be? It might be a day's work for someone to go into the office and pull out the files, or to find the right email account and conduct some keyword searches, or to go onto their home computer or their office computer and find their finance folder. I mean, the claim, there is a difference between the parties on this. UBS has branches and offices around the globe. So when it has to carry out a disclosure search, even within particular countries, it will have lots of different offices. So when the bank has to carry out a search, it's potentially a big job, a lot of places to look. But for 2 private investors, how many places do they need to look? How hard can this be? The time that we've spent in this hearing today is probably long enough for them to go into their office or go into their home and find these files. And I'd like you just to reflect on that point when considering whether there's a genuine legal basis for opposing these requests, or whether this is because this is something the claimants really don't want you to see. Now that perhaps I think is a neat introduction to me just going through the requests, if I may, quickly. And I'm going to do that. Can I do that by reference to our document production so our document request, which is in the main bundle at B tab 3, page 386.
Yes, I got.
So I'm going to.
Yeah.
I'm very grateful. I've tried to deal with the concepts together so that I can deal with these categories quite quickly. And if my learner friend decides to develop, then I will come back to these when I reply to his submissions. So request 1 are the claimant's own investment records over the relevant period. They're relevant to all of the 6 areas that we identified. And my learner friends are quite fairly pointed out that the end date should be the 9th of April 2020, not the 9th of April 2021. And I agree with that. So I'm content to cut it back in that way. But we say that these are the sorts of records they'll have in their home file or on their home computer. They're probably electronic records, so it's probably quite easy to gather them. And they'll give the court insight into what investment activity the claimants were doing elsewhere over this period. So if I move on now to the next category, request 2, that's on page 398. And these are documents that relate to their classification by other institutions. And I've already explained to you why classification is relevant, why it remains an issue, even if my learned friend is right on strikeouts. But it goes to 5, basic classification goes to 5 issues. The first issue is knowledge, experience, understanding, and appetite to risk. The second is understanding of the classification regime. So if the claimants have been classified by lots of other people, that would go to their understanding. The third is the classification elsewhere will go to whether it was reasonable for us to do the same thing. I've given your submissions on that. The fourth is causation. So if they had not been classified as professional clients by us, would they have simply gone and done the same investments elsewhere? And then the fifth point is relief under Article 65(5). And I've addressed you on that as well. So there are 5 areas where classification goes, and those and this still remains an issue even if they succeed on strikeout. The next categories are 3 to 5 and 7. So that's page 401. And I'll just summarize what these are. So category 3 are documents that go to the claimant's knowledge and experience and show information about them investing or understanding high-risk products. Again, I mean, these are going to be in the same place as the claimant's other financial records. They're probably on emails, and they can just be extracted and searched from the emails. It would be easy to do keyword searches because we know the names of the institutions, and the claimants themselves will know the institutions that they had accounts with. So that's all relevant to the claimant's knowledge, experience, understanding, and appetite to risk. Then the next category is category 4, which are communications with other institutions about their investment objectives. Obviously, their investment objectives are crucial. It's a factual matter in dispute in this case. They say that their investment objectives were stability and safety. We say that they were content to invest in high-risk products. Then moving on to categories 5 and 7. So 5 is on page 406, and that deals with appetite to risk. That's obviously an issue in the case. And 7 goes to whether or not they can enter higher risk transactions. So that also goes to risk appetite. Now, my learned friends say on 7 that there are not any documents that go to this category. Now, this category is about giving the bank permission to show them high-risk products. And they say, oh, we don't know of any documents. But that, with respect, can't be right, because we can see from the very limited documents we do have that they were being shown high-risk products, recommended high-risk products by other banks. And I just want to show you a couple of those. So if I may, we'll come out of this document for a moment and we'll go into tab 2, page 2571.
Correct me if I'm wrong, it's 2571 main bundle, yeah?
That's right, exactly. Main bundle. It should be an email from the top email is an email from Saw Brothers on the 12th of March 2013.
Right, yes.
Very
That's
good.
1153, yes.
Yep.
Right.
Now, I'll just explain what this is. So what the claimants have done, because actually I'm not entirely clear from this email which claimant it is, has forwarded to the bank, to Credit Suisse, is a request to buy a lot of a product. And then the product, if you look at the product below, there's an email from Bank of Singapore, which must have gone to Mr. Sawhney, which is why Mr. and Mrs. Sawhney, which is why they have the email. And it's got a recommendation on it. The subject line gives a name of a particular instrument and it says trading buy. So you can see from this is a recommendation from the Bank of Singapore to the claimants for a product. And then if you go to the second page, sorry, you go to page 2573. There's lots of details about this product. And then can you see the bottom box on 2573? There's a word that says risk rating. Does Your Excellency have that?
Bear with me, the page is downloading, please.
No problem.
Yes, I have it now, finally.
Very good. So there's a box at the bottom on the left that says risk rating. Do you have that? This is page 2573.
I got first box description, issuer description.
Yeah. Oh, yes, that's perfect. So that if you look right at the bottom of the
BOS,
page.
yeah. Research view, trading, then
At the bottom,
risk rating 5, yes.
Yes, okay. 5. And then I'll tell you, if you turn over to the next page, it tells you what 5 means.
Yes.
So at 2574 at the top on the right, it says 5 means very high downside risk. So that is the maximum level of risk.
I beg your pardon, I cannot see this. Where next page you said?
Yes, next page at the top.
Immediately next page?
Yes, 2574.
Yeah, the risk rating, yes, I see. 1 very low
Yes. And then
and
if you
5
go,
very high. Yeah.
yes. So what we can see from this email exchange is that the Bank of Singapore made a recommendation to the claimants to buy a very high risk product. And now the claimant's position is when we ask them for agreements that allow them to buy products other than low risk products, they said, well, there are none. But how is that the case? Because we can see that Bank of Singapore is making recommendations to them to buy very high risk products. So there must be an agreement with Bank of Singapore that allows them to do that. And Bank of Singapore is not the only bank
So
that is
the
doing
description of this risk is to the transaction, not to the client. Yeah, let's agree on this. It's transaction description being highly risky transaction.
Yes, exactly. You're absolutely right. So, but that is relevant because the claimants. So this goes to lots of different issues. It goes to their knowledge and experience. It goes to their understanding. It goes to their appetite to risk. But their case is that their investment objectives were only stable and secure investments. And they say that there are no agreements that allow other banks to show them products other than low risk products. Now, how can that be right when we can see that Bank of Singapore recommending to them products that have high risk?
Well, I can frankly say this is an incomplete picture for me because I really didn't understand the transaction. We do not understand the arrangement between parties. We do not understand how risk is managed and mitigated in this scenario. We don't understand, we didn't see, I mean, who's running the transaction itself, whether the bank or the parties themselves. We don't know if this was done through the claimants or through intermediary level or third parties running this. We don't have the full picture of this. We understand they are invited to get into a high risk transaction only. Is that right?
So I agree with those points, but actually it's that latter point that matters. So the simple point is we have said, are there any agreements between you and any other financial institutions that allow you to buy products that are not low risk? i.e., are there other agreements that allow you to buy products that are higher risk? And they say, no, there are no such agreements. Now, how can that be right if Bank of Singapore is inviting them to invest in a high risk product? Now, I agree with Your Excellency's point that we don't understand the full sophistication of the transaction, but that's not relevant to my point. All I care about is that this is a high risk product. They obviously had a relationship with Bank of Singapore that allowed the bank to recommend high risk products to them. And we say, where is that agreement? And it's not just the Bank of Singapore that we can see this happened on. There is also, we'll go to DBS as well. And that is in the same tab, tab 2, page 2581.
Bear with me, please. I'm just doing my notes as well.
No problem, no problem. Sorry, I'll just say on Bank of Singapore, actually, sorry, this is an important point. Could you, before we leave that, could you just go to 2577?
Yes, I'm in.
So this is the email footer, and it tells us that this was Bank of Singapore in Dubai. Email square.
Yeah, I see that.
Yeah. So this is not some, this is not some sort of foreign regime that this court's not going to have any understanding of how it works. This is
locally regulated business.
Exactly, locally regulated business, which Your Excellency will be very familiar with how that works, and they're recommending very high risk products to the client. And the client seems to be saying there's no agreement under which the Bank of Singapore was doing that. And we say that just can't be right. Now, that's not the only institution. I'm just going to take you to have a look at DBS at 2581. So it's the same tab, I tab 2. Page 2581.
This is email dated 24th March, yes.
Correct. And so this is a sort of similar pattern to the previous one. This is an email from the first claimant to Credit Suisse, but he's forwarding an email below to him from DBS Bank. And that email sets out a US dollar denominated bond issue from Standard Chartered for 30 years. And if you look at the table at the bottom, there's a risk rating of 5C. Can you see that?
Yes, I do.
Yes, and then if you go to the next page, 2582, it tells us what those risk ratings mean. Now, this is actually quite interesting because this deals with a point that Your Excellency made a moment ago about whether we were talking about the risks of the product or the risk appetite of the client. So the way that DBS work, they say in the middle there under product risk rating. Have you got that?
Yes.
Yeah. So they say 5 risk rating. So product risk rating levels 1 to 5, 5 being the highest. And then they explain 5 is commonly accepted by PB clients, which we think is private banking clients, with high risk tolerance level. So that's very important because that grapples with Your Excellency's astute observation that when you're looking at products, you do have to understand whether when you're looking at risk, are you looking at the risk of the client or the risk of the product itself? So on this, it's quite clear that when DBS are making that recommendation, they are recommending it for PB clients with a high risk tolerance level. And that, again, as we say that this sort of material, this is a snapshot in time, and we'll need to see the full record over the relevant period. But this will help assist Your Excellency in deciding at trial whether or not these clients had a high risk tolerance. And it would obviously be significant if lots of other finance institutions had assessed them to have a high risk tolerance, and that there were lots of documents that explained that, as this seems to the claimants. I mean, is it really the case that the claimants are likely to be have missed this? And especially if there are lots of this and lots of institutions doing this, is it really the case that this is all a terrible mistake and that the claimants didn't realise that these institutions thought that they had a high risk tolerance?
So the claimant in this scenario is bringing such offer to the determination of the bank, isn't it? It's like he's consulting with the bank.
Yes.
Is that something we can deal with?
Well, that is something that we deal with, and that obviously that's how we know about it. But what I'm saying to you is that these sorts of documents are going to help the court decide what the characteristics of these clients was like. So when they say, when the claimants say to you they were unsophisticated and had no appetite for risk or very low appetite for risk, Your Excellency will be assisted by these sorts of documents to see what other banks were advertising to them. And of course, other banks wouldn't have been able to advise them or recommend them to invest in very risky products if unless those other banks had assessed these clients as capable of taking that level of risk. So that's a really important point. And that's all going to feed into the factual inquiry that Your Excellency is going to carry out at trial. Now, I should say that my learned friend says, oh, well, it's a very short trial. It's only 6 days, and we're not going to have much time to investigate these sorts of issues. But I mean, that's nothing to the point. I mean, these are obviously going to be key questions on which the claimants will be cross-examined. And also the court will adjust the length of trial according to the volume of material. So if the court feels that trial is quite congested, then it may be that the court decides to give us an extra day or two. And at the moment, the trial hasn't been listed, so this is all a very theoretical. The length of trial is a very theoretical concern. So these documents, they go to category 7 because we want these agreements that show whether or not the claimants invested in high-risk products with other institutions. But it also goes to causation. Again, it helps the court decide that if Credit Suisse had turned around and said, we're not doing these investments with you, whether the claimants would have simply done them with somebody else. So if I may, I'll move back to my categories now. We'll leave this and we'll go back, if we can, to main bundle, tab B, tab 3, page 409.
Page 309.
409.
Yes, we are.
Very good. This is request 6, which this relates to direct agreement. So we had a direct agreement between the claimants, which allowed them to trade directly with one of our trading desks, without going via an advisor. The claimants dispute that they understood this arrangement. They say they didn't understand the agreement that we provided. We say they did understand it. And they also advance a case on causation. So they say that essentially, if they'd understood the true position, they wouldn't have done these trades. And whether or not they had agreements like this with other institutions would inform the question of whether they understood them, and it would also inform that causation question. Now, the claimants say they don't believe these agreements exist, but there's no evidence that they've actually conducted a search for them, and they ought to do so. If we go forward now to page 411, that's request 8. This is in relation to margin calls. Now, as Your Excellency might have come across before, margin calls are made by the bank where there's a shortfall on the bank's obligation, the client's obligations to the bank. So normally the client has suffered a loss on something. It's often coupled with some sort of debt, and the bank says you owe us money because your investments have suffered this loss, so you need to top it up. And margin calls tend to be made on products that carry a degree of risk. They tend to be on higher risk products. So if the claimants were facing margin calls from other banks, then they likely had a good idea that these were risky products, and they also would have likely had a good idea that these are the sorts of products that might lead to margin calls. We want to have details of those margin calls. We allege in our pleading, paragraph 2.7 of our defence, that they faced a number of margin calls, and they deny that at paragraph 2 and 3 of their reply. So that's an issue in the proceedings. We say they should provide this category. Moving on then, if I may, to paragraph.
But
sorry.
how wide is this category? I mean, just to be fair to the claimant, so.
Yes, but I mean, they're private investors. Even if they had accounts of 12 other institutions that we know, it would be extraordinary, we say, if there were a large number of margin calls over those periods.
Well, Mr. Shefley, if we're looking at the documentation associated with this proceeding, yes, we are already thousands of documents. We maybe it's going to be 10th of that thousand soon. But if you're acquiring the claimants to do the same, almost let's say, same process with every bank or financial institution he has dealt with, from call log, documentation, contracts, everything is as similar to a document that we're trying to produce in this, we would end up in maybe millions of documentation, isn't it? So.
Well, so firstly, I'm not asking for that broader category of material. So what are the things that really bulk out the document production in this case? Well, it's the contact notes. There are over 1,000 of them, and the telephone calls. And my learned friend has said there are 2,700 of those. So I'm not asking for that material. We have formulated much more precise categories, often asking for agreements, or in this category, details of margin calls, or in another category, confirmations of other dealings. Now, if the answer is, I've done 10,000 trades over a 10-year period, that in itself would be a very significant factor for Your Excellency to take into account. I mean, if the answer comes back, well, we've done thousands of these over this period, then that is going to assist Your Excellency in deciding whether these were sophisticated investors or not. So this is the case the claimants have chosen to bring. It's not our fault that they are suing us on the basis that they are unsophisticated and inexperienced. That is the case they want to allege. Your Excellency is going to have to fairly decide on that issue. And if it carries with it some document production obligation, if it ends up being an extensive set of documents, that is on the claimants. It may well be that the reason I would submit why this application is being fought so hard is because that sort of information would be devastating to the claimant's case. It may actually mean the end of the claimant's case if they have to reveal what they were up to with our other institutions. But that shouldn't cause Your Excellency to be squeamish about ordering it. And I would say this is fairness not just for UBS, but fairness for the banking community and the DIFC. That we say that DIFC Bank should not be exposed to these sorts of claims, where investors, on our case, don't give a fair characterization of their experience and knowledge, and appetite to risk or objectives. They put forward an incorrect and unreal assessment, and then try to deprive the court of the opportunity to probe the true position. So if it ends up being a big volume of documents, that is just tough luck. And my learned friends don't say that they can't afford this. They can't afford to give document production. They can't afford the mechanics that would be usually deployed for document production. It would have been open for them to put in that sort of evidence to say we're impecunious, this is too difficult for us. And they don't do that because I would submit they can't fairly put forward that case. So there are there's no evidence that this would put this to the claimants in an impossible burden. And I bring you back to the point that I mentioned at the beginning. I mean, let's say they were very active investors. They had staff, they had their own business. There will be a set of files somewhere. Now, maybe it might be one file if they're inexperienced and unsophisticated, as they say. It might be just 20 pages of bank statements. But if they are, as we say, very sophisticated people, it might be 10 files. It might be 20 files. But so what? I mean, that is what the court will need to grapple with in order to fairly try this dispute. And we don't want the DIFC to be known to be a jurisdiction where investors can effectively take advantage of the banks. That would be unfair on the banks. So they've got to play by the same rules that we do. So anyway, I'm saying all of that. The margin calls, even on our case, I don't think would be a very substantial body of materials, because it would be, I mean, a lot of investors manage to navigate their entire financial investment careers without facing any margin calls at all. I have managed to do that, touch with so far.
Maybe class 9 would be.
Yes. Oh, yes. Your Excellency is right. So you're right. Class 9 is broader. Now this goes to an issue. Can I explain what the issue is?
Yes, please.
And then try and find a way. I'm very open to suggestions to try and narrow the class to make it fair. I don't want to overburden the claimant, so I don't have a problem with this. The issue is that our pleaded case is that the claimants shared their knowledge and understanding experience on investment decisions and made their decisions together. So we say that on investments, they worked together. And we also say that each of them had the authority to act for the other. And those are pleaded issues at paragraph 20.2 and 20.4 of our defence. Now, that is disputed, so that is an issue in the case. And my learned friends seem to try and run a legal argument on the authority point and say that we couldn't win on that. But they haven't tried to strike out our case. That is our case, and it's obviously going to be an issue for trial. Now, I recognise that between husband and wife over a 9-year period, if the messages between me and my wife are anything to go by, there's going to be a lot of them. And so I recognise that you're going to have to find a way of trying to cut this down. We're not interested in personal messages. There'll be lots of private family things or other things that have got nothing to do with this case. The messages are also highly likely to be electronic. I mean, that is how a lot of people communicate these days. WhatsApp or messages, depending on your jurisdiction, WhatsApp, or if you're not allowed to use that, instant messenger or Facebook Messenger or whatever the system is, there will be some way of doing it. And those, because they're electronic documents, they can be extracted electronically and searched electronically. And I am completely open to any ideas that the claimants have to try and limit this. I mean, we've come up with some keywords like Credit Suisse and the name of the relevant investment advisors to avoid it capturing anything that's not to do with this case. And what I would suggest on a class like this is that the claimants go and extract the information and then they can review it and apply some of these search terms and see if they can get the population down and ensure that they're hitting the relevant documents. And of course, what often happens in these cases is a party goes away, does that and says, look, actually, we're getting a lot of irrelevant hits. Sometimes you get irrelevant hits because an email footer might have a lot of information in it and it's not relevant. And so then a party suggests some more limiting keywords. And that's fine. That's the sort of dialogue that should happen in this case. And I'm very open to discussion. As I said, I don't want anything personal from the claimants that have got nothing to do with this case. But the claimants seem to step from our request for a category that is at risk of being broad to saying we should get absolutely nothing at all, not one of these messages. And that just doesn't work. I mean, how is the court going to assess this question of whether the claimants were working together on a particular investment or whether they made a decision together if it doesn't have a look at any of the communications between them, even if those communications are actually relevant to the point of question? So I'm very sympathetic to the idea that we cut it down, but I say that just because it's broad doesn't mean that we should get nothing at all. If I may, I'll move on then to request 10. So request 10 is similar. This is a category of communications between the claimants and their employees and agents. And again, we've tried to limit that to matters that are relevant to this case. Again, they're highly likely to be electronic communications, given that we're talking about the last 2011 to 2020. And in particular, this goes to a pleaded issue at paragraph 20.3 of our defence, where we say that they used their members of staff and drew on the knowledge and experience of those staff. And we mention in particular one member of staff, and that was an individual called Sonali Singh. So again, with some sense, this ought to be cut down to a way that's manageable, and I'm open to all suggestions on that. If I move on to request 11 quickly, this is hard copies of agreements provided by the defendant to the claimant. Now, this is an important point because they say there's a big dispute about what they got from us, whether documents were filled in an incomplete way or whether they got the full documents. So they ought to look for what they have. They say they don't have them, but they don't actually say that they've conducted a search. All I'm looking for is for them to give some particulars of the search they've carried out. And as I said, that ought not to be a difficult search to do. Request 12 is in relation to hard copies of our documents. I mean, again, I'm very interested in any shortcuts the claimants might have on this front. We had proposed that if they were willing to accept that the portfolio statements that we have on our systems had been provided to them, then we don't need to have hard copies of the documents that we know we've already sent them. This is to cover a scenario where there's a dispute over what the claimants received. And again, they ought to be able to go away and find a way of cutting this right down. I mean, it doesn't require lots of duplicate documentation to be provided. Request 13, this is to do with the claimant's net asset position. So under the rules, a firm can classify a person as a professional client if they meet a particular threshold, and there's an argument over whether the claimants reach that threshold. We say we carried out that assessment. They say that we've got it wrong. The true position will illuminate that question. It's also relevant to the case on causation. So they'll have to show that if we'd carried out the assessment that they say we should have done, it would have led to a different conclusion. And so we will need to see the documents that we didn't even see about their financial position in order to see what the true position was. This is a very narrow category of documents. We've been very cautious to select them. We've chosen essentially samples from particular points in time to give a snapshot of their financial position. And in terms of the financial statements for their own business, that must be information they have readily available. That's exactly the sorts of records an entrepreneur would have easy to find. Can I just deal with the final two categories, and then I'm looking at the time, we might, subject to your excellency, we might want to have a break. So this is request 14, and this relates to Mrs. Sawhney's degree certificate or results or any equivalent documents. So sorry, I'm just bringing up my reference to this.
This is educational certificate, isn't it?
That's correct. That's right. Let me just explain a little bit of background while I'm just waiting for the document to come up on my system. So our case is that Mrs. Sawhney was a graduate in finance. We plead that in our amended defence at paragraph 25.1.1, and the claimants deny that case. We asked for Mrs. Sawhney's degree certificate, as I said, or transcript of results or equivalent. And the only document we got was a certificate from her teacher training course. Now, if that's in the main bundle, I'd like you just to have a quick look at that. It's at tab D. Main bundle, tab D, tab 3, page 925.
Yes, I see that.
Yes. Now, this just to contextualize this document, this is the out of our 15 document production requests, this is the only document that the claimants have chosen to produce, and it's a certificate to show that the second claimant completed her nursery teacher's training, a one-year course in 1990, when she would have been about 27. 26 or 27. So it's long after the point one might do a degree. Now, my learned friend in his skeleton argument describes this as a degree certificate, but that, with kindness, that seems to be perhaps elevating what this course was. It's not a university qualification as far as we can see. Normally with a university qualification, it mentions the university. To the best of our knowledge, this isn't a university. Now, what we do have, in light of my learned friend's skeleton argument describing this as her degree, we actually found the second claimant's Facebook page, and I will just show you that. This is in the supplemental bundle. I'm so sorry. I'll give you the reference. 1 second. Yes, so this is a supplemental bundle folder, tab D, tab 2, and it's page. We wrote to when we came across this, we wrote to KBH on Friday to ask about this. Now, admittedly, they haven't had very long to see it, and I'll just show you a screenshot. This is at 636. Now, actually, I'm not. I'll take you to this document. I'm not actually convinced that this was the screenshot attached to the letter. I think it was another screenshot, but I think it had the same information. So I'll just show you this screenshot, and my learned friend can then address you on that when he comes to it. So do you have that document 636?
I do.
And this is, as we understand it, the second claimant's Facebook page captured at the end of last week. And in the details of where she studied, it says details, worked at self-employed, and then the next item is studied at Kamla Nehru College, Delhi University. So now we had understood she had gone to university, and it's clear from this Facebook page that it appears to suggest that she went to Delhi University, and we don't understand that to be the same thing as the teacher training. Now, we've asked my learned friends about that, but they obviously must give us a complete account of her education. It's a bit, it would be a bit unfortunate if actually there was some other studying aside from her teacher training and they hadn't mentioned that. And of course, in terms of what the court is having to navigate at trial, it will want to know the true position. So we would like to know what those studies were at Delhi University. We don't think that's the same thing as the teacher training. We think that was a different institution and likely at a different time. And the claimants ought to produce that material. So anyway, that's request 14. And then I'll request 15, rather than go back, just to save time, rather than go back to my request, I'm just going to tell you what it is and explain to you what we're after. So these are the instant messenger messages, including text and WhatsApp, between the claimants and our advisors. Now, we don't have these documents. Obviously, long after the event, we don't have them in our possession. So, and we think they'll be useful for the court. They're an electronic set of documents. My learned friend spent a lot of time emphasising the importance of the court having a complete record. The logic of those arguments goes to this material. My learned friend seems to suggest that all these messages will be relevant and material, but the only one they've actually produced, and I'll give you the reference, but we don't need to look at it, is at D tab 3, page 869, and that is actually obviously relevant and material. And they've obviously cherry-picked that from the body of material that they've got. and we say there's no reason why they shouldn't have the rest. Because they're electronic documents, they shouldn't be difficult to extract, they shouldn't be difficult to review, and we ought to just provide them. And ultimately, we think it will give Your Excellency some assistance at trial to have the fullest record available. So, Your Excellency, that brings me to the end of my requests. I'm just looking at the time. I obviously need to come back on my learned friends document production requests, and there's a couple of other things that I need to address as well. But I think we're making reasonable time. Would now be a convenient moment for us to have a break?
I guess so. I think this is the right time to break, and then you will run next when we come. You will run your second application.
I will run my second application.
The information application.
Yes.
And then you will
and just to
yes.
Yes, and just I'll obviously need time to deal with both my response to the DPO application, the RFI application, and my reply to the strikeout.
See, when we come back, I think what I'm intended to take a break, not long one, up to 1 o'clock. So we'll come back by 1 o'clock. So that is just less than half an hour, about 20 minutes. Then we'll have a 1 hour and 30 minutes, I mean 90 minutes. So I would like each of you utilize half of that into the best effort of putting everything in that timing. Because I will force stop by 2:30 as I have another hearing to get in. So we'll come back then at 1 sharp. We'll continue with the defendant for the remaining of his application and whatever defense he got. Then we'll end our submission for today with you, Mr. Knott, for the last 45 minutes. Clear? See you at 1.
Thank you.
Thank you.
Good afternoon, Counsel.
Hi, good afternoon, Your Excellency. So I'll turn now to the claimant's application against us for document production. I can deal with that, I think, pretty quickly. Now, in my learned friends skeleton argument, there was a request 17, which was a proof of delivery of a particular agreement by courier. That was actually a new request in that it wasn't in their original request, but that's fine. We've dealt with it anyway, explaining that we've looked and we didn't have it. We can confirm that in writing, but I noted that my learned friend hasn't pursued that already. I think he was right to do so, given that we've reached the end of the road on that. So that was request 17. The next item was request 22 and 23. So these were requests about the policies. And I wonder whether actually we'll start by looking at request 23. And this is at in the main bundle, B tab 4, page 435. Sorry, 437. Sorry. No, I'll try again. Page 436. So this is B tab 4, page 436.
Right.
has that worked? That was B tab 4, page 436.
Yes.
Very good. So I want to start with request 23. Now, I mentioned to you before that there were only, out of the 41 categories that the claimants originally requested, there are only 3 that are being contested where the bank has said objects to the category and says it's not doing anything at all. And this is one of those 3. Now, the request is for the defendant's internal policies and or guidelines and or procedure manuals relating to the provision of financial product performance information and or spreadsheets with clients. Now, we'll unpick that in a moment, but it's worth remembering that it's common ground that there is no case against the bank that it breached any of its own policies. That is not a case that's being advanced. And what the claimants want with this category is the defendant, I think that must be read as Credit Suisse, given the time period of the relevant part of the case. They want Credit Suisse's internal policies and or guidelines and or procedure manuals relating to the provision of financial product performance information. Now, just pausing there. This is that category of financial or product performance information is going to cover the bank in all its different offices, across all of its different products, across a whole range of different time periods. The claimants have made no effort to try to identify what products we're talking about, what time periods, which offices, and what does this go to? So let's say, for example, that the bank, this is entirely hypothetical, I'm not referring, and I haven't looked at any of the policies because I haven't received any of them and the clients haven't conducted any searches for them yet. But let's just say there was a policy that said you've got to send a financial performance information sheet to the client once a month. And we only did so every 6 months. What bearing would that have on the case? Would be in breach of our own policy, but that wouldn't go to issues of client classification or client experience or sophistication, and it wouldn't go to the suitability of the products. Wouldn't go to any of the issues in the case. It would be, admittedly, an error. Sometimes institutions do make an error in terms of following their own policies, but it wouldn't illuminate any of the issues in this case. And that's, of course, a policy. They don't just want policies. They want guidelines and procedure manuals. And what would those guidelines be? We could be talking about a wide range of things, that briefings that are given to employees when they're taken on, compliance reviews. It's potentially an enormous category. So our objection here is that this isn't focused on any of the issues in the case. And it's, in fact, it's not focused at all. They haven't made any attempt to actually identify what they're looking for. Now, the bank has always been very reasonable about document requests. And if the claimants had been able to say, look, there's some specific issue that we're concerned about, then we would have looked at that. And it was quite telling that when you heard my learned friend's submissions on this, his focus, he didn't focus on this category at all. His focus was on suitability. And suitability is a different request for policies, and we'll look at that in a moment. But there was nothing.
To be fair, I'm not here to substitute the claimant's position, but I understand this comes from the claimant perception that they are not a professional client and open to high risk transaction. They are laymen's, and from that basis, this is hypothetically, I would like to think that what the claimant trying to say, the policy and how the bank takes decision in regard of this financial or product in the course of dealing with the people of that level of expertise. They are not high risk investment. They are laymen's. So that's how I think the claimant put his case. And from that basis, he wanted to know how the banks take decisions in this kind of case, in these scenarios, where you do not have high risk investment clients.
So there's an easy answer to that question, which is that Credit Suisse didn't have a retail endorsement at that time. So it wasn't permitted to trade with retail clients. So there's no reason to think that it would have any policies on what was the appropriate approach, for example, as you identified, of communicating with retail clients, because it wasn't allowed to do that. So I think if that's what the claimants are after, they've answered their own question. If the question is, did you have a set of policies to do something you didn't have regulatory permission to do? And the answer is, well, why would you? So I think we can sweep that away. And they don't ask for any policies about the classification process. So actually, neither 22 nor 23 ask us what our classification policy was. They don't think that's relevant. So we don't have to worry about that point. So in my submission, there is just nothing in 23 that goes to an issue in the case, and it's too broad and unfocused to be helpful. It's going to put us to work, and they're not going to get anything useful out of it.
So this is the case, is the defendant at the time, and this course of dealing between 2016 and 2021, and not taking on board a retail client.
We didn't have a retail endorsement. Can you just check when? We don't think we had it. We might double check that, but I don't think we had it at any point. And certainly the point, I mean, perhaps what matters is at the points where the classification was carried out, we didn't have it. We were a professional client only outfit. So the points in issue, the points of classification in issue in this case, we were a professional client outfit only. And that's the claimant's point. The claimants say, if you had classified us correctly, you would have assessed that you couldn't have done business with us. You would have just had to turn us away. And that's why it also feeds into, well, what would you have done if Credit Suisse had turned you away? And we say, well, you just would have gone and done the trading you did with those other institutions anyway. So that does rather short.
And if go to the second limb, if the claimant at some point, either by this court or by themselves, convinced that, so this is a professional course of dealing, and then how decision is made, how decision of going to suitable product or the discretion in taking what investment or what portfolio or what to sell, what to buy, and how that made, how your employees and the directors of the banks or the relationship managers take decision with or in behalf of the professional client.
So can I just understand that question? Are you asking that if they lose on classification?
Yeah, why they still cannot run this as like the discretion or the suitability of a product chosen can be something that the bank would be blamed with.
Yeah, so if they lose on classification and they were correctly classified, they can still advance a case that the products were unsuitable, although it becomes very difficult for them because the foundation for their case on suitability is that we were unsophisticated. So if we were right that they were, I think this may be a sort of theoretical debate, because the way they found their case is they say we were simple, unsophisticated investors with a very basic investment objective. And if they lose on all of that, then their high risk products are suitable for them. So I actually find it quite difficult to see how conceptually that would work. But my learned friend's point also is that a product is either suitable for a client or it isn't. And the question of suitability is going to be a question for this court by reference to the regulatory regime. And you may well have the assistance of factual and expert evidence in those questions. And we would say that the procedure, whatever the procedure is not going to help you. I mean, I showed you that Justice Cook decision that said this is not about process, this is about substance. So let's assume there was some great process failure. The bank made some great process mistake. That would have no bearing on the question the court's got to grapple with. And that brings me to the request 22. So maybe we can just have a look at that. That was at 435. And again, it's an incredibly broad category. Internal policies and/or guidelines and/or procedure manuals relating to the assessment of suitability of products, trades for clients. Now, actually, what's quite interesting about this actually touches on a point that Your Excellency made earlier, that there's a distinction between the risks associated with a product and the characteristics of a client, the client's appetite for risk. And this is focusing on the products and the trades. So this is actually asking about the suitability of product classification of products rather than the classification of clients in terms of their risk. And it's again, amorphous category: policies, guidelines, procedure manuals across the whole bank, across unlimited time, unlimited numbers of products. So again, we just say this is not going to assist Your Excellency, and the bank, you can understand why the bank doesn't want to be at the trouble for trying to hunt for this sort of material. Now, if the claimants had come up with something more focused and they could show issues it goes to in this case, we would look at that seriously. That's how we've approached the whole of document production. And I'm not shutting the door on them coming back and asking for something if they actually can come up with a genuine reason for it. But as these categories stand, as the way they've chosen to fight the case today, those are not sensible categories. And that is why the bank is objecting to them. My learned friend also spent a bit of time looking at the DFSA's thematic review on suitability. And we don't think that's going to be very illuminating. So that review was conducted as a result of work in 2019 and 2020. And Your Excellency's probably come across these regulator reviews. They're designed to improve compliance by the industry. So actually what regulators often do is they do a survey of the whole industry and they look at the state of practice and say, let's try and move best practice on. And they try to do that in an inclusive way that really brings the community with them. The question of whether or not a product was suitable in the period from 2016 onwards is not going to be answered by reference to that thematic review. It's going to be answered by reference to this court's adjudication on whether or not specific products were suitable. So, I mean, these sort of very general, let's move the community on surveys are not going to help the court in its inquiry. So I would say that none of that's illuminating either for the courts that you have to decide. So if I may, I might move down to the rest. Sorry.
Move on.
If I may, I might. Thank you so much. So I'm going to go to request 37, which is at page 452, please, of the same document.
Right.
And if you look at, so this is written records, they basically want itemized telephone bills for particular phone numbers. And if you go over to 453, there's a list of the numbers. Can Your Excellency see that?
I do see it.
Now, what someone who's intimately knowledgeable about the UAE will note is that these numbers start with a 5 and are cell phone numbers. And they're not landline numbers. Now, my learned friend spends a lot of time in his skeleton argument saying it's very odd that you've got all these recordings of phone calls and itemized records of phone calls, and yet you say that you don't have itemized list for these 4 numbers. And what my learner friends don't seem to have understood is that numbers starting with a 5 in the UAE are cell phone numbers. So in contrast to the lines that we have provided, which are fixed line recorded lines, these are cells. And what we're talking about is cell phone numbers from the period 2012 onwards. So that is 13 years ago. Now, Your Excellency asked the right question, which is, were we under any obligation to keep these records? And my learned friend quite rightly said that we weren't. There was no regulatory requirement to do so. And the way that he put it was he accepted that there was no regulatory obligation to keep it, but then went on to say that it was surprising, given the regulatory obligations of the bank, that we hadn't. But that doesn't work because there was no obligation to keep this. And Your Excellency probably knows from data protection that the sort of converse requirement, on the one hand, one meant to keep records up to a point, but we're also required to delete material when it's no longer reasonably necessary. So that's a data protection requirement. So institutions can't hold on to records forever. They have to keep them according to their regime, and as long as they're no longer necessary under the data protection regime, then you get rid of them. So there's nothing odd or surprising that the bank doesn't have core records for cell phones for an 8-year period starting some 13 years ago. Now, what the bank has produced is call records from its Zurich office in 2019 and 2020, and it also has about 2,700 calls on recorded lines. And I'm going to come and deal with those in a moment. Now, on these cell phones, we have looked and we have no records of them in our possession. And as I said, these are not records that we maintain. So there's nothing untowards in relation to us not having this. I should hasten to add that my little friends make no allegations of dishonesty against the bank. No one is suggesting that the bank is crooked. These are just records in the midst of time that we no longer keep, and there was no longer a requirement for us to keep them. That then I think brings me to request 38, which are the telephone recording, the 2,700 telephone recordings. So the first point is, my little friends want to know why we've got no recordings prior to August 2016. And the answer for that is that the regulatory regime only requires us to keep records for 6 months. And that's Conduct of Business Rule 6.7.3. So there's no reason to be suspicious of the fact that we haven't got anything prior to 2016. There's no requirement to keep them. In fact, we weren't obliged to keep the records even for that long, but for various internal reasons we had done so. Now, in terms of what we've produced, my own friend says we've produced about 500 of these calls. That's right. He says we've cherry picked. I think that's a little bit unfair. What we've done is we've produced the calls that we intend to rely on, and we've also produced any specific calls that the claimants have identified. So where they've identified something specifically, we've said, fine, you can have that call. And we're not closing the door on that. If the claimants can identify any specific calls by reference to the pleadings, we'll provide them. But if a specific call doesn't arise on the issues in the case, at the moment, we're struggling to see how it's relevant. And of course, there were many transactions over many years, and there'll be no issue in relation to many, many, many of these calls. So we just say on a relevance ground, we don't see the relevance. But again, I'm not shutting the door on my learned friend on this. If he wants to, having reflected on it, come back later on and say, actually, now we've done some more work, and here's some specific calls and some specific reasons, the bank will be sensible about that, as we have done throughout. Now, the reason why we're unkeen to produce the whole body of the calls is because many of the conversations were not in English. They would require some sort of transcription and translation for the legal team to review if they're going to be put in play. That's obviously has a cost burden as well as a timing burden. And at the moment, we just don't see how it's going to help anybody. So we'd rather not be sent off to do a blanket exercise for just a whole volume of data when no one has been able to identify anything specifically relevant. As I said, I'm not closing the door on them, and we will revisit that if they want to come back specifically later. Now, my learned friend made two criticisms of us in relation to specific calls. One is in relation to a call on the 11th of March at 2020. And my learned friend said that we haven't produced that call. He said there was confusion over how long the call was. And actually, there's confusion over whether we provided it. We say we have provided it. And there was a confusion over the length of the call. I don't want to bore you on the technical details, but we think what happened was in the spreadsheet that produced the call length, the formatting went wrong and the length of the seconds and the minutes got flipped around. That's what we think. We're trying to figure it out, but that's what we think happened. So it was recorded as 32 minutes and 8 seconds, but we think it was 8 minutes and 32 seconds. And the call that we have is an 8-minute long call. So that seems to match up. So we just say it seems to be a discrepancy in the record that we produced because the data didn't get extracted properly. But they have the call. If they've got any queries about the call, we're very happy to deal with it. They should just write to us about that. And if we get an answer on this swapping around of the minutes and the seconds, we'll write to them about that as well. That's at the moment our working theory on what happened. So there is no mystery.
What I consider this is a system generated statement, isn't it?
It is, but if you
usually such mistakes doesn't happen that way, or it could happen to many figures.
So you're right. So I said I wasn't going to bore you on this, but I may have to bore you for a second. So you're right, it is system generated, but actually if we look at it, we can have a look at the relevant sheets. We just think something's gone wrong on it. It might just be the way the data went into whatever the underlying spread. I think let's have a look at this. So this is at E tab 4, page 1102. Has that come up? This is
It's downloading. It's downloading.
Amazing. Okay.
Yes, I got it now.
Amazing, thank you. So this is actually a document produced by the claimants, not ours. I mean, I think it's based on data that we'd obviously given them, but it's their spreadsheet, not our spreadsheet. And if you look at the duration of the call, the column, most of the items have one colon in them. So they have a time and then a seconds after them. So for example, the first entry seems to be 1 minute and 50 seconds.
Right.
Can you see that? But if you look down to line 2691, which is the relevant call on the 11th of March, can you see that?
(2691), yes.
Yeah, that's right. And do you see there that that's in a different format?
The 3rd of November, yeah.
It's actually the 11th of March, but yes, that's it exactly. So that's in a different format. Do you see the time? It's got two colons in it. It's 32:08:00.
Yeah, I do. I see this. Yes.
Yeah, so it's in a different format, and we think something's gone wrong with the data in that cell, because with the exception of one other call, all of the other calls are in a different. The call lengths are in a different format. And we actually think that something.
There is another call in the same format, which is 2682.
There is one. You're absolutely right. There are two calls in a different format, and we think we've only investigated the 11th of March call. We haven't investigated the timings of the other call, so I don't know the answer on that. But on the 11th of March call, we think this was an 8-minute call, not a 32-minute call. So in the second, if you sort of follow the format, the middle set of data has 8 minutes, which we think is right. So that's correct. It's the 32 that's wrong. And we don't know where the 32 has come from. And the 32 might have actually come from the seconds.
Yeah, cannot be 32 hours, yeah.
No, exactly. So it's an error. But as I said to you earlier, no one's suggesting that the bank is dishonest on any of this. The bank is trying to do its best. There are sometimes discrepancies that come up. We're not, I mean, the whole load of technical people at the bank who are helping with this, and the call that we have located is an 8-minute call. So we think there's just an error in this spreadsheet. There isn't some mystery 32-minute call, or it's not like the Watergate tapes where there's some missing minutes. This is just, that's what we found. And we will continue to investigate it. And if we can give some more information on this call, we will do so. But we have also produced that to the claimants. So we think that is a storm in a teacup.
Yes.
And then the other call, which was the 24th of August. Now that is a call that we thought we had, but we can't find it. And we will continue looking for that. We don't know why it's not there. If we can come up with a reliable explanation as to what's happened, we will provide that. So again, there's no suggestion that the bank is involved in any wrongdoing. This is just the nature of withdrawing historic records. And Your Excellency has probably come across this from other cases, but where you have vast amounts of data sets, there are sometimes corruption issues and other problems. So we say we're being very cooperative in all of this, and if we can help in the future, we will do so. And then the final category was request 40, which was in relation to internal communications relating to the claimant's complaint from 2016. Now, I think we will just need to have a quick look at the complaint, please, which is at E tab 4, page 1145.
Right, I got it.
Great. So this is an email from the claimants, the first claimant, to the bank about this complaint, and it follows a meeting. And in the second paragraph, this first claimant says, "Thank you for sharing the revenue details. I hope the management wouldn't have now realised that my concerns about excessive revenue being charged to us was true and genuine." And then he says, "When we meet tomorrow, I'll share with you my concerns, observations. However, the figures that have been shared with us do not seem to be giving the information requested by us. For example, during our discussion on the 26th of September, we had requested for more details of revenue earned on all transactions." Now, there is no suggestion in these emails that there was any complaint about the suitability of products. And that is the only complaint, apart from classification, and again, that wasn't complained about. Classification and suitability is the only complaint made in these proceedings about the products sold by the bank. So there was no complaint about suitability. That's common ground in these complaints. And then I wanted to show you how what the bank understood the complaint was about. And that's at page 1110 of the same tab. So E tab 4, page 1110.
Yes.
And it's the first line. This is from the email from the bank to Mr. Sawhney.
This is 1 year later, because the other one.
Yes, this is exactly. Yeah. So this is right at the end of the chain. So what I'm trying to show you is the evolution of the discussions, and there were discussions about loss suffered by the claimants on their transactions, but there was no allegation from them that the products were unsuitable. And the critical point is that the bank understood this as a complaint about the fees being charged. And you can see that from the first sentence of this email. And this email is right at the end of the process. So pulling together essentially all of the discussions and thoughts. It says, "Thank you for your patience whilst we have verified your request for details relating to the revenue generated by the bank in regards to your investments with us." And then we go on to talk about the fees. And this is essentially the end of the process. So this is where it ends up. And there is another email. If we just go If we go over then to 1112, this is an email from Mr. Sawhney again to the bank. I was not able to speak with you. I've been very busy with some urgent matters. I do not want to be impolite, and I'm sure that I will respond to you on all pending issues when I'm back. I have read the mail yesterday with regard to our issues related to past trades will result in huge losses for us. I had not time to look into the details. I'm very disappointed that our main complaint has not been addressed. Let us meet when I'm back so that I can once again share my concerns with you with regard to past trades and investments, which will result in huge losses for us. So that was his email. And then if we go forward to page 1115,
But in the same email, this is 1112, where the claimant is emphasizing that he would share a concern with regard to the past trades and investments.
Yep. But my point is that didn't happen.
And not just the fees, I mean.
No, I understand that. But my point is that didn't. I want to now show you what happened to the complaint. So the complaint was about excessive revenue.
There.
Yeah, but yes, I understand that. But my point is, so if I show you 1115, and then I can just make good this point.
Right.
So is 1115. Okay,
yeah.
Good. You're in there, fine. So in the middle, there is an internal email in the bank asking someone to update them on the complaint following the final response that was sent on the 5th of July. And I've shown you that 5th of July email. That was about excessive revenue. So that's what that was the bank's response to the complaint. And then if you go up an email, the response is there is no further update as of now. You may close the complaint on the system as the client has not formally responded to our final feedback until now. And then if you follow up the chain onto 114, they asked, the internal person asked for the final response that was sent and said that was required for us to formally close the complaint. And then that was sent to the complaints to people. So my point was the complaint that was made was about excessive revenue. That is what the bank investigated. Now, I agree that there was a response from Mr. Sawhney saying he would come back with further complaints or that they hadn't addressed his main complaint, but he never did so. And there's no evidence from my learned friends that they did so. So what my learned friend wants is copies of the own bank's internal investigation. But of course, there was never a complaint that the bank had to investigate because the details were never provided. And you can see from these documents that the bank didn't get a follow-up, and so it closed the complaint on its own records. So my point is there's no value in us going and conducting a search for this material because what we understood we were investigating is quite different to what the claimants are now suing us for. And this is, again, one of those areas where it's one of the three areas where we just say it's not worth the trouble. Why should we be conducting a disclosure exercise to go and find this material when it seems to have no bearing on this case?
Mr. Shafji, I would like to remind you, you got 7 minutes only. If you
I know. I think we're doing all right.
Yeah.
I am. So thank you for reminding me. I think we're doing all right. So that actually brings me to the end of the claimant's document production order. There were just a couple of very small items remaining. One is in relation to our application for further information. Now, we've largely covered this ground, so I can deal with this really quickly. So we've asked for further information about the classification of the claimants as professional clients by other institutions. Now, there is an inconsistency in their reply because I've shown you in our defence that we pleaded that other institutions had classified them as professional. They deny all of that in paragraphs 2 and 3 of their reply, but then later in their reply at paragraph 38.1, they say that unbeknownst to them, they were categorized incorrectly as professional clients by certain other financial institutions. It's their phrase, certain other financial institutions. And because of that inconsistency in their pleading, where on the one hand they deny any such classification, and then elsewhere seem to say, yes, actually there were some, we asked for further information. And we asked them to identify those institutions, identify the relevant period, etc. Now, my learned friends have objected on two grounds. Firstly, they say that it's an irrelevant issue, and I've addressed you at great length as to why it is a relevant issue. I've given you 6 issues, 3 factual and 3 legal. So that's the first point. The second is that they say that the information would give rise to a disproportionate burden. And we find that really hard to understand. I mean, we know with 12 accounts, we're talking about 12 relationships. It really isn't hard for them to decide whether or not they were categorized as professional by those clients. We say what's obviously going on here is they don't want to reveal what happened because it's very embarrassing for them and very problematic for their case. But we say it'd be useful for Your Excellency to know that. We say we need to know that. There's nothing disproportionate about that. So I would say that that just follows the logic of the relevance of these issues. And ultimately, what we're trying to do is narrow this dispute, try and focus the dispute so that when we get to trial, Your Excellency has the things that you really need. So that's our request for further information. I just wanted to mention a couple of other points. Firstly, can I just say a small point about the document production in light of Swiss legislation? And this is not a big point because it's not a barrier to us producing anything. But Your Excellency might have come across this from other cases that in Switzerland there are client confidentiality laws and data protection laws, and some of those laws make the disclosure of information a criminal offence. And so when it comes to producing documents for these proceedings, the bank's view is that it is better in terms of explaining itself to the Swiss authorities if it provides information voluntarily than if it's ordered to provide it. Now, obviously, I understand for the purposes of today's hearing that if you make an order that something should be provided, I understand that if the bank doesn't comply, then the court would expect that order to be complied with. So I don't have an issue with that. But what I would suggest is that when the mechanics of the order are drafted, the court just makes a ruling on the theoretical relevance and need to give the documents, and then maybe gives us a period of time to comply voluntarily. And that, as I said, that's just a sort of wrinkle on our side to give us a window to give what's needed. And that's something I'm not going to go through the mechanics now. It's something that the counsel between the parties should be able to negotiate in light of your judgment. But I just flag it because it was something that we obviously want to make sure we're compliant with laws in Switzerland. We're not going to stand in the way of giving Your Excellency anything that Your Excellency thinks you need for this case. But I just have to make sure that I'm not putting my client Swiss employees in trouble under Swiss law in the way that we do this. Your Excellency, I know I've got 2 minutes, and if I may, in those 2 minutes, I'm just going to double check my notes to make sure I have covered everything I said I was going to.
You did.
Thank you. Well, thank you for your patience as well. Let me just see. Agenda. So it's just finally, there is a draft order in the bundle, which I'm not going to take you through the mechanics of. You have it there. I mean, obviously, you'll need to reach a decision on the substance, but that just appears at page. This is tab 19, page 380 of the supplemental bundle. So that is the draft order that we're asking you to make. And those are my submissions.
Thank you very much, Mr. Sabji. Thank you very much. Appreciate it. Claimant.
Thank you. I'll just very briefly reply in relation to the strikeout application.
First of all,
and
do
my
we have any
submission-
update in regard of the matter that we have adjourned? Is there an agreement between parties in that regard?
Actually,
So
yes,
far?
there is an update, which is that Mr. Shivji and I spoke very briefly during the adjournment, and Mr. Shivji is, I understand, taking instructions from his client as to whether or not our, as it were, counter proposal is acceptable. The noises I was getting suggested he thought it might be, but he was taking instructions and was going to update as and when that came in.
Great.
So can I just drop in on that, because we can sweep this point out of the way. I'm very great. My learned friend was very constructive, so thank you very much. His proposal is that as I understand it, they're content with our proposal that I outlined orally, but that they would like a liberty to apply at a later stage in the event that they decide that they're unhappy about some aspect of this. And I'm content with that liberty to apply. So we are agreed.
I'm content too.
I'm grateful for that. So just very briefly, in relation to the strikeout application, we do say that it's important to focus on the distinction that is drawn in the defendant's case between the two new pleadings. My learned friend made a lot about the fact that we aren't seeking to strike out one, but we are seeking to strike out the other. And I just want to show you that the paragraph that we're not seeking to strike out is not a backdoor into the relevance of this material. We can find it at A6, page 237. So that's main bundle A, tab 6, page 237. Your Excellency will be familiar with this by now, but just
Yes.
to emphasize,
To be formal, yes.
when we look at 84.8.1a, which is what we're not seeking to strike out, what we have there is a pleading of fact that the defendant was aware. So it's a plea of the defendant's own awareness. Now, obviously, nothing that we can give document production on can go to the defendant's own awareness. That's something for the defendant, is peculiarly within the defendant's own knowledge. And that accords, we would say, with the COB rules that we looked at, where the focus is very much on the defendant's process, what the defendant was aware of, what it took into account, and the records that it holds. And that is why 84.8.1a is not relevant to the document production aspect, because that is only pleading the defendant's own awareness, which is not a matter that we can comment on or give evidence in relation to. That's what our documents are not in its head. Now, 84.8.1b goes much wider and encompasses a proposition that even if the bank was not aware of any classification, any particular classification or any particular analysis, that is still relevant. So it becomes relevant after the event. And really the way that learned friend tries to hang it is the reasonableness assessment, or the word reasonable in the rules. But for the reasons I gave, that reasonability falls to be tested by reference to the rules themselves. They provide a complete code and the criteria by which to assess it. And so what the court has to distinguish between, and what the rules distinguish between, is what the defendant knew, what it took into account. And the rules provide that that is what the test, that is how the decision has to be made, and the defendant has to keep records in order to be able to justify that after the event. We'll see that in a moment. Separately,
Mr. Note, yes. I don't know if you remember as well, because the defendant not just speak about 84.8.1a, but he said the issue is remain intact when you look at 84.8.1 itself, where he described your client as a professional client. If you look at the last line before A, before the red font, the last line.
Yes, and again, the same.
Where he said remain, and then I recall he said a reference like this is being mentioned across their submission. So it's not helping you asking to strike out 84B1B. Because that won't,
if I can deal with
that, literally that won't help you.
Yeah, well, I disagree with him on that. We're not ad idem on that. But with regards to 84.8.1, which Your Excellency has referred me to, that again, if one looks at it carefully, is a denial that the information supplied by the claimants, so that's what we gave them, and the analysis undertaken by the defendant, so that's the analysis it undertook, did not provide reasonable grounds. So again, the focus there, in contradistinction to 84.181b and what the contradistinction there is what we supplied them with, the analysis they undertook, and the decision they reached on the basis of it. So 84.8.1 and 84.8.1a go together. They are focusing on what the defendant knew, what we gave them, and the decision they reached. And that is a matter on which the decisions by other banks that they didn't know about is irrelevant. So what we're focusing on is the very narrow proposition that even things that they weren't aware of are somehow relevant to the reasonableness of their assessment. And my simple proposition is that is not made good by the COB rules. And a submission was made, a sort of ad terrorum submission, that if the court were to rule on this, that it would cause it would potentially cause problems in the industry or something like that. But in my submission, it's a simple proposition of law. It's self-contained, and the court shouldn't shy away from grasping the nettle and striking it out if it concludes, as in my submission it should, that it's hopeless. And we do say that on the basis of the COB rules, it is hopeless. And you were taken to no authority, let alone DIFC authority, that makes good the proposition. And so what we have to go on are the COB rules, and the COB rules are very clear. Now, a further point was taken, which I'm not sure was preceded in the skeleton, but a reliance was placed on Article 65(5) under the regulatory law, which is a defence that can be pleaded by banks. And in relation to that argument, we have really 2 points. The first is that the actual pleading of that defence is not pleaded by reference to any particular facts that the bank says it either took into account of or was entitled to take into account of. So we can see the defence itself at tab B3, page 399. Sorry, that's a wrong reference. It's A6251. And it's at the final paragraph on that page, 95.4.7. In any event, the defendant reasonably believed that it was not in breach of the financial services position, and it would not be fair and just for the court to order the agreements entered into to be enforced and the money paid to be retained. So firstly, again, the focus there is on the defendant's belief, not on anything outside of that. And the defendant's reasonable belief, or the reasonability of the defendant's belief, falls to be determined by reference to what they knew. And that is reflected in the wording of Article 65(5) itself, which we have in the supplementary bundle at B tab 17, page 604.
Mr. Note, what you say to the point that's raised by your counterparty is that the bank during that time do not take retail clients anyway. They only take professionals. So you,
well, in a sense,
your client is going walk in to the bank. I don't know. They have to be only professionals. And
well, in a sense, that's the point. That's the point. That as Mr. Shivji very fairly put it, the point is the first part of the claimant's case is that because classification is a discrete exercise. It happens on discrete occasions. So there are 4 occasions throughout the relationship where classifications were made or purportedly made by the bank. And on each of those occasions, we say the bank got it wrong on the basis of the material they had. And if they did get it wrong, then they were in breach of the financial services prohibition. So that's the first element of the case. The second element of the case is irrespective of that. So even if we were correctly classified, we say the products were unsuitable. Now, Mr. Shivji's submission was that it would be very difficult for that to succeed. I don't accept that for one moment, for this reason, amongst many. The bank itself, the bank's own records, and indeed the only records that they have that purport to contain our signature in relation to their risk rating, classify them in 2012 as medium risk. And then we see later in the relationship the selling of numerous high-risk trades. And so it's far from fanciful that the bank could have failed in its suitability requirements, having recorded themselves the defendants, the claimants, as medium risk. But the short point is, to Your Excellency's question, that yes, the heart of the first part of our case is that we were wrongly classified on 4 discrete occasions. But irrespective of that, suitability case remains. So there are two aspects. Just very briefly, just so you can see Article 65.5, it's at page 604 of the supplementary bundle. And it's really 65.5a, if the court is satisfied that the person carrying on the financial service reasonably believed. So again, the focus is on the reasonability of the defendant's belief. And we would submit that, again, that falls to be determined by reference to what the bank itself knew and understood, and not. So
you're reading 65.5a?
5a, yes. If the court is satisfied that the person carrying on the financial service reasonably believed that he was not in breach of the financial services provision.
I see that.
So what is being tested there is the belief of the bank and whether it's reasonable. And that can only be tested by reference to what it knew, i.e. the basis of its belief. And in my submission, so there are really 2 points on Article 65. One, the pleading is a bare pleading, which doesn't actually allege that the bank should be entitled to this defence by reference to classifications by other banks. So it's not actually pleaded. But the second point is that even if it were, it's irrelevant under Article 65 because that goes to the belief of the bank. And so I would urge when considering the application, I would urge upon Your Excellency that you do separate out in your mind the 2 very distinct features of the pleaded defence: what the bank says it did know and what it ought to be able to prove, its own state of mind. That we have no issue with. That's a matter that is peculiarly within the bank's own knowledge. And on the other hand, the ex post facto, the after the event relevance of classifications and analysis by other banks. So those are just brief reply submissions in relation to the strikeout. Now, in response to my learned friend's DPO application, and whilst on the subject of the relevance of other banks, one of my learned friend's key submissions, he described it as critical, and he also tried to made essentially an analogy of a trap that could be set for unwary banks, and it was by reference to the decision in the BASMA case. And if we look at that briefly, Let's find my note on it. So the case that you were taken to was BASMA and Credit Suisse. So it's supplemental bundle B7, page 430.
Right.
So there are really two main points in response to it. So you were taken to paragraph 19, and this is the critical point that my learned friend said or submitted was critical, which is that if an investment is in fact suitable for the client, then it does not ultimately matter if there's been failings in the process. And my learned friend used this to try to introduce this idea that if a product is suitable, it doesn't matter if the bank hasn't done its job. And I want to show you that that's wrong.
But still,
Now,
there's supposed to be
first
a suitability test, isn't it, in here?
Yes, and I don't take exception to the fact that the bank must test suitability, but there is a subtle but crucial difference between a test by which the bank has to decide on suitability itself on the basis of the material it has, and a different test, which is, well, ignore what the bank did. Was the product suitable, objectively speaking? And that is not the right test. And first thing to note is that this is a different regulatory regime. So this is the English COBS rules, not the DIFC rules that this decision is dealing with. And we can see, and this is not just an objection of form, this is an objection of substance, because the rules are different. And we can see that if we look at page 428 in this document, we can see a quote from what the judge describes as the relevant COBS rules 9.2.1 at the top. And at the top, a firm must take reasonable steps to ensure that a personal recommendation or decision.
What page is that, Mr.
Sorry, Your Excellency, it's 429. I do apologise. I've given you the wrong reference. 429. Paragraph 17, yes. And the judge cites the relevant position. So COBS, these are the English rules. And in little one, a firm must take reasonable steps to ensure that a product or recommendation is suitable. So the product must be suitable. That's an objective, appears to be an objective test. And in contradistinction, the COB rule in this jurisdiction is 3.42. We can find that at page 278 in the same bundle.
Yeah.
And the suitability assessment at 1, an authorised firm must not recommend to a client a financial product or service or execute a transaction on a discretionary basis unless the authorised firm has a reasonable basis for considering the recommendation or transaction to be suitable. So the focus there is on a reasonable basis for it considering it to be suitable. Not that the product is suitable, but that it has a reasonable basis to consider it so. And in undertaking that consideration, it has to undertake an appropriate assessment. So there is a subtle but crucial distinction in the rules in England and the DIFC. Secondly, so that's the first point, different jurisdiction, different rules. Secondly, as appears from the relevant paragraph itself, so if we go back to 430, my learned friend started his citation from that paragraph, from the middle of the paragraph, but as you can see from the opening of paragraph 19, it is common ground that, so far as relevant, taking reasonable steps to ensure that an investment suitable for the client involves taking reasonable steps, and then at the end, and that the rules are concerned with substance and not form. So the point wasn't argued in that case. It was common ground, so it was concession amongst counsel. And aside for the proposition that if an investment is in fact suitable, then it doesn't ultimately matter if there's been failings in the process. We see Zaki and Credit Suisse at 102, and we can see that paragraph at page 581 in the bundle. main bundle. In fact, it's 580. It's right at the bottom of 580. It goes over the page. But all that paragraph does is say that COB doesn't specify what factors must be taken into account. So this is, again, the English rules. COBS 9.2 does, however, identify 3 factors which information should be gathered to enable a determination. So that is not authority for the proposition that if the bank gets the process wrong, there's no breach. And again, it seems to have been common ground in any event, because at the end it says there did not appear to be any dispute that these factors were relevant to an assessment of suitability under COB as well. So again, 2 points in relation to suitability and the case that you were taken to. Firstly, it's irrelevant, different jurisdiction, different rules. And secondly, in any event, it doesn't demonstrate support for the proposition even within the case itself. And my learned friend made the submission that, well, what would happen if a bank doesn't have its suitability records, if it loses them, whatever? Well, the answer is, in a sense, that the rules are the rules. The rules require the banks to maintain records in order to defend themselves. And we can see that from the way the DFSA itself analyzes the position. And we can see this from the review of suitability at 566. Sorry, that's 566 in the main bundle, not the supplementary bundle. Now, my learned friend said this is not likely to be a relevant document at trial, but for my purposes, it is relevant insofar as it goes to the nature of the rules and the nature of the records required and the nature of the relevance or irrelevance of these documents. And it addresses expressly at 576, page 576 in the same document, the importance of record keeping. The last paragraph on 576. We remind authorised firms of COBS 3.6, which requires firms to maintain for a minimum of 6 years sufficient records relating to suitability assessments to demonstrate compliance with COB 3.4.2. Authorised firms are reminded that a failure to document suitability assessments may leave them exposed if the investment decisions are challenged subsequently and the authorised firm is unable to evidence the rationale behind those decisions. And that's the point. The reason you keep records and you are mandated to keep records as regards suitability, as regards classification, is so that when a client like Mr. Sawhney, like Mrs. Sawhney, comes before the court and says, you bank have failed in your obligations to me under the rules designed to protect me, the bank cannot turn around and say, we have no records, we didn't do our job, but look, these other banks did, it's fine. That is not an answer, and the COB rules do not require it to be an answer. And that is guidance from the very regulator that wrote the COB rules. And so the suggestion that suitability falls to be assessed by reference to anything other than the bank's records, and that a breach of the rules falls to be assessed by reference to anything other than the bank's records, is in my submission wrong. It's not supported by the case cited, it's not supported by the DFSA's own guidance, and it's not supported by the rules. Bear with me one moment. Time. And at one point, it was suggested that it was submitted that there is, in some way, a contradiction between in the way that we put our case, But our case is put, as it must be in this jurisdiction, by reference to the COB rules. And the COB rules, as I say, focus on what the banks knew, what the banks did, what the records the records that banks kept. If in fact, as the bank says it did in a very general way, if in fact the bank relied on any particular thing, and it says that it was aware of particular things, then that is something that is, as I say, peculiarly within the bank's knowledge. It's something that the bank can be expected to have records of. What they cannot do in my submission, in a context of a regulatory regime which is designed to protect the client and emphasizes compliance with the rules and record keeping, is to say, well, we didn't keep those records, or we don't have those records, or we didn't do the job, but it's okay because someone else did our job for us, and we can look at that after the event. That's not how the regulatory regime is designed to work. And so those are my submissions in relation to, as it were, the general points that were made about suitability and the general points that were made about relevance on the pleadings. And that runs really throughout the entire case, because what this case turns on is what the bank was told, what it knew, the decision it took at each individual stage, whether that be classification, whether that be suitability. And in relation to each one of those decisions, did it follow the rules? So did it carry out an assessment at all? We say it didn't. And even if it did, what did it rely on? And anything that it didn't know, we say is entirely relevant to that process. And I think it's another way of perhaps putting the same submission, but a learned friend spent a lot of time aiming his submissions at a process by which the court could arrive at some truth about the claimants. But that is not what this proceedings, this claim, is aimed at. And it's not what the COB rules are aimed at. They are not aimed at, they're not designed to permit a bank to sit on its laurels and subsequently rely on some objective truth that the court is going to find after some state trial about what other banks did, what other banks knew, looking at all of their procedures, deciding whether those banks got it right. It's a satellite point. The truth for the purposes of this claim is whether the bank complied with the rules on each occasion when it was required to. That's the truth that the court needs to find. And no amount of material after the event that the bank wasn't aware of is going to change that. That's the investigation that is required.
So you say it's not about the characteristics that the defendant trying to suggest?
Yes, and even characteristics. So characteristics, knowledge, experience, the things that the bank is required to take into account, those are listed specifically in the criteria that my learned friend took you through, the criteria that the bank itself has to have regard to when it is carrying out its assessment. So it has to assess whether the claimants meet those criteria, and it has to do so in accordance with the rules, and it has to keep records of what it used to meet that assessment. What that doesn't do is import in after the event process, where all of the world of material, which was completely unknown to the bank, suddenly becomes relevant, simply because of the word reasonable. And crucially, the reasonableness is of the decision at the time. It's not in the abstract. And in my submission, what the defendant is trying to do is to create a sort of abstract of reasonableness. But that's not what the rules require. The reasonableness is tested at the time on what the bank knew. Now,
you mean at the time
by way of
at the time of classification, what kind of a client is they having when he's
yes, well,
that's what's relevant.
It's both in relation. Yes, forgive me. It's in relation both to classification and to suitability, and there is a difference. There is a difference in the, as it were, I suppose the regularity, the timings of both, because classification is a discrete exercise at discrete points in time. So you have, at certain points, the bank will look to classify or reclassify. Suitability is something that the rules require the bank to take to carry out an assessment every time they recommend a product. So every time one of these trades that we complained about, of which there are hundreds, was made and recommended to us, the bank was required under the rules to carry out an assessment, and it pleased that it did carry out an assessment. And insofar as it relied on material to do so, it will have that material. Insofar as it didn't, or it doesn't, then it's irrelevant. Now, as regards the specific requests, I'll whiz through these because it's I've got, I think, 14 minutes by my watch. Requests 1 to 5 of my learned friend's request, it was said that these were, a lot was made about how they've been specially tailored to be narrow and confined. Well, they're anything but in my submission. One only has to look at, for example, number 1 at page 386 of the main bundle. First request. In the first column under document, portfolio, account statements, confirmations, term sheets, and other documents recording the transactions that the claimants entered into with or via other financial institutions between, and then a decade. Now, on its face, that captures every single financial transaction the claimants have entered into over a decade. Any transaction the claimants entered into with or via other financial institutions for a decade. Now, that is as wide as a request could possibly be. And my learned friend said, well, we could have come back and tried to narrow it down. Well, in a sense, what's good source of the goose is source of the gander, and the same point can be applied to my learned friend's requests, where, or rather our requests, where my learned friend says we've been too broad. There's been no attempt to narrow these down. And the same applies really for nearly all of the requests, all of which relate to, or nearly all of which relate to a decade-long period in relation to incredibly broad categories of documents. And another example of the breadth is that none of these requests, so for example, requests 1 to 5, which deal with relationships with other financial institutions, none of them are, for example, limited to this jurisdiction. And even if my learned friend is right as to the relevance of classification and suitability, which I don't accept, but even if he was, what possible relevance could analysis carried out in other regulatory jurisdictions have to whether the bank in this jurisdiction breached its obligations under the FSA rules?
You're suggesting it's different regulatory regime by jurisdiction.
Well, they're plainly are. The English position has its own COBS rules. No doubt other jurisdictions will have their own equivalent of the DFSA. They'll have their own equivalent of the regulatory law. The bank providing any services, or whatever financial institution providing any services, will be subject to a different regulatory regime. But what the bank has not said is, well, we only want to see DIFC. They want everything. And even if they're right on relevance, which we don't accept, there's no world in which non-DIFC institutions could possibly be relevant, because it would entail this court at trial having to grapple with potentially expert evidence on other jurisdictional regulations and other jurisdictions' laws, which would be an entirely fruitless exercise, given that we're not concerned with breach of those rules.
Yes.
So very briefly, to the time.
You have 9 minutes.
Thank you. Just looking at my notes. So in relation to request 6, so these are agreements with other financial institutions envisaging that the claimants may trade directly with the trading desk. The short point, and this is in my skeleton, so Your Excellency will no doubt have regard to it, but the relevant paragraphs of the particulars of claim, which I'll give you for your note, which are 41. Well, it is 41, paragraph 41 of the APOC, which is at page 37 of the bundle, and paragraph 59 of the defence, which is at page 214 of the bundle, simply plead what the defendant and Ms. Kaliappan did or did not tell them about particular this particular agreement. And that is reflected in what the actual substantive issue on liability is, which is whether the defendant's communications were clear, fair, and not misleading. And that's paragraph 74 of the particulars of claim at page 63. And whether the defendant's communications were clear, fair, or misleading plainly falls to be addressed by reference to the communications between the claimants and the defendant, and not communications with other financial institutions. And in any event, as Mr. Singh has explained at paragraph 18.1 of his witness statement at page 931, to the best of the claimant's knowledge and belief, no such documents exist or are within their possession, power, or control. So an order would serve no purpose. In relation to request 7, agreements with other financial institutions envisaging that the claimants may purchase products other than low-risk income-bearing products, you were taken to 2 documents where there were references to trades with other or trades from other institutions which were appeared in email chains with the defendant. The mere fact of the existence of those documents doesn't imply or infer or support that there are extant agreements. The claimant's position, as Mr. Singh states in his 6th statement, paragraph 18.1, is that no such documents exist or are within the claimant's possession, power, or control. And in any event, the other basis on which that's relied upon is causation. But causation requires the court to consider what would have happened in a counterfactual, i.e. not what happened in actuality, what would have happened but for the defendant's breach. And in my submission, the claimant's relationship with other financial institutions in the events that did happen, i.e. on the premise that they were introduced to these trades that they were unfamiliar with, is incapable of going to the hypothetical. In relation to request 8, margin calls by other financial institutions, the actual paragraph relied upon in the defence, 2.7, is simply part of the summary of the defence and doesn't in fact lead anywhere in the substantive defence itself. There is no substantive defence pleaded by reference to margin calls. And so it doesn't go anywhere. As regards request 9, communications between Sanjeev and Alka, so between the claimants, Mr. Shivji very fairly accepted that this was a potentially extraordinarily wide request over a period of a decade of communications between husband and wife. The only real point it goes to is said to be agency, but in our submission, in the absence of any pleading of a specific basis for ostensible authority, whereby something crossed the line over to the bank to suggest to the bank that there was an agency relationship. And if that were the case, the bank ought to be able to identify it. And we say there's no relevance to this, and that in any event, it would be a unfair burden to impose upon the claimants to conduct this search. I don't think in the 4 minutes I have left I can get through each one of the requests. So what I will urge on Your Excellency is to have regard to my written submissions in relation to those and to the claimant's objections. So this is in relation to requests 10 to 15. I just want to deal very briefly with 2 points. The first is in relation to the degree certificate, Alka's degree certificate. A point is raised as to the way it was described in my skeleton, and that was really the basis for the whole submission. And there's no magic in it. The words nursery teacher training degree, which are the key words that are fastened on, are the defendant's own words. They appear in a document index at page 668 of the bundle, which was an index to their own bundle of documents which went in with the application for the DPO. And the document is described in that index as nursery teacher training degree. And as the document is plainly a certificate, the fact that the skeleton simply borrows the defendant's own words, nothing can come from that point. It's the defendant's own wording, so they can't use that to suggest that we've given something away. It's their own words. And finally, in relation to request, just briefly in reply in relation to request 40 in our DPO, it was submitted by my learned friend that it's common ground that the complaint in question was not about suitability. That's not quite right. What I submitted was that the word suitability was not used, but I don't accept that the complaint was not about suitability. It's clear from the context that I took you through that there was a complaint in relation to that issue. And Your Excellency, if I may say correctly, picked up the point that the document at 1112 of the bundle that Mr. Shivji took you to, which was the last response that we have in the bundle from Mr. Sawhney, says, "I'm very disappointed that our main complaint has not been addressed." Now, the bank then goes on unilaterally to say, there's no response, we're shutting it down. But there plainly was a response. Mr. Sawhney has said in terms, in response to the response about fees, that's not my main complaint. It has not been addressed. He couldn't be clearer. There was a main complaint. It wasn't addressed. And that main complaint was plainly relevant to suitability. So the fact that the word suitability was not used, I accept that. But I do not accept that the complaint itself did not address or concern that issue. Plainly did. The bank sent it to compliance, and there should be records of what that compliance review, what the result of that compliance review is. And there's no reason why we shouldn't see that, because it's plainly relevant. I think, Your Excellency, I think that, by my watch, brings me to the end of my submissions. All I would say is to mirror Mr. Shivji's submission in relation to the terms of any order. Plainly, Your Excellency is going to have to go away and come to a decision and do so carefully. There will no doubt be submissions that either side would wish to make on the terms of any order once you've reached your decision in principle as to what should be the result. And I'll simply reserve my position in relation to that, as Mr. Shivji did.
Sure, I will. I think the decision I'm going to take is that I will reserve for decision to make over the 4 application before me. And when I do that, alongside that, I will give parties also a chance to submit on cost. So once you know what is my decision, I will give you for chance to submit a kind of short submission on cost.
Very good. Your Excellency, can I just, with your indulgence, my learned friend made some new points about suitability in his submissions that were not addressed in his skeleton argument, and I haven't had a chance to deal with them, and I think it's important I do. It will take me less than a minute, if I may.
Please.
So on the Al Suleiman case of Justice Cook that I cited in my skeleton, my learned friend didn't cite that case, or indeed the Zaki case. He seemed to be asking you to rule today that as a matter of suitability under the DIFC, you cannot look at the characteristics of the client. Now, that is not a point that has been argued properly. It wasn't foreshadowed at all in his skeleton. That would be a very significant ruling for this court to give. And we say that's a matter for trial. Now, the reason he had to argue that, obviously, is that, as he put it, he didn't think the court had to look at the objective truth, his term, as to actually what the position of the claimant was. But of course, it's exactly the court's function to look at the objective truth.
Well, he fairly said it's a different regime based on a different regulatory law and framework. Yes, and assessment must be given to the jurisdictional framework. That I think what he said.
Yes, that is right. So that's what he said. That's obviously not my case. My point is simply that that is a point for trial. You can't assume that his case is correct, nor can you assume that my case is correct. At the moment, there is a dispute over that, but the documents I seek are the documents to support my case. And of course,
well, we are here to resolve dispute, Mr. Shavji.
Yes. Yes, exactly. So, but the critical point is that these are the documents that I need to prove my case on suitability. There's been no suggestion from my learned friend until those submissions a moment ago that you could engage with a ruling on suitability at this stage, and it would obviously be quite inappropriate for my learned friends to encourage you to do so, because the point has not been properly argued. And this would have quite significant ramifications for the market. And of course, in this case, my learned friend glossed over this entirely. There is a major factual dispute as to what was said at these oral meetings. We say that we were told that they were experienced investors. We knew that they had been classified as professional clients, and they deny that. And of course, the objective truth, to use my learned friend's submission, is what your Excellency is going to have to look at to work out what happened at these meetings. So we say that once you see the dispute, don't look at the case as the claimant puts it, but see actually how both parties put it, that then sets the landscape for the documents that have to be given, and that you should decline to rule on suitability at this stage. So thank you for your indulgence on that front.
Thank you very much. What's left is just to thank you, counsels, for your appearance and for your preparation. Thanks for the team behind you. I wish you a good day ahead, and you will hear from me soon. Thank you very much.
Thank you very much.
Thank you.